Beg your message pardon, some criminal appeals for bail, specifically adjourned but not listed.
That is a bank matter, madam. It is not fair to distribute EMI in time. Therefore, the bank will proceed as it is. If I representation for one time, they are not being consulted.
Criminal appeal for bail once it was rejected.
My lord, one criminal appeal for bails.
Appeal for bail in several spots.
Regulation of service, 30-year service. It is on the board of retirement.
Criminal appeal for bail. And it is a read petition. It was earlier mentioned on 10/9/2025, and it was allowed to be listed, but till today it is not listed. My lord.
What is the matter?
My lord, the petitioner are out of service since 2023. So, your lordship may list it.
The order of the Central Administrative Tribunal has been challenged or what? Out of service, mean what?
What have you
It is-
challenged? Is it against the
It is against the
tribunal's
state
order?
of Odisha. My lord. State is the opposite party. My lord.
Honda?
State.
State is opposite party, it's all right. But have you challenged the tribunal's order?
I will not gone through the file.
Read it and come tomorrow.
Mention tomorrow. Yes.
Matter 2016 writ appeal matter when the honorable single judge decision has been challenged. For honorable single judge decision has been challenged for the demand of additional security and anything further security.
Give it.
My lord, item number 23 of today's first up list that will kindly be taken up before losses rising the first bench because that involves the auction sale of the residential property that stands in the name of the deceased guarantor.
Proceed. Yes, next.
Before rising the lordship.
After.
In view of the discussion made in the preceding paragraph, we do not find any infirmity, perversity in the impugned order dated 15/11/2019 passed by the Debt Recovery Tribunal, which necessitated for interference by us in this writ petition. Accordingly, the writ petition fails and dismissed with no cost.
I agree.
Lord, I want to make a mention. Item number 4. Item number 4, there is a connected matter. Against common order, 2 writ applications have been filed. The other one has to be listed along with the present writ application. My lord. It may come along with the other one on some other day. Item number 4.
The detailed order was passed on 24/6/2025.
But no interim order is here.
No, we asked you something.
Yes, ma'am. Your lordship directed to furnish the file number. By then it was not numbered. So now it is numbered, regularly numbered.
What
And
is the number?
number is WPC 28863 of 25.
Of the phone.
WPC 28863 of 25.
And maybe part item number 4.
4.
I may be pardoned to mention my Mr. Mishra and Council, Central Government Council submits that the chances will be connected to this petition and can be listed along with the present petition put of this matter on 22nd of October 2025 with WPC number available.
I may be pardoned, my lord. Item 1. On behalf of Mr. Pradeep Mahapatra, my lord, he is in bereavement. And His elder sister died, he is in bereavement. Today is the 11th day, my lord. On behalf of Mr. Pradeep Kumar Mahapatra, my lord. He is in bereavement.
Who are the other counsel on the other side?
For the still appearing for the respondent, your lordship.
Respondent or sole respondent?
Sole respondent, your lordship.
देखिए रीटर फिल्टर देखिए the first title down. So we are adjourning to some other dates here. The bereavement in the family.
Day.
What is your good name?
Dheeraj Behera, your lordship. A Behera.
A Behera. Acha. Mr. A Behera, learned counsel for the respondent is present. You have got power in
Yes,
this
my
case?
lord, I have
What-
got power. SK Jetty, my lord.
Mr. S.K. Jetty, when counsel appearing for the appellant submits that Mr. Pradeep Kumar Mahapatra is supposed to argue this writ appeal on behalf of the appellant is not able to attend the court today, as there is a bereavement in the family. And the matter will be taken some other day. And counsel for the respondent has no objections. List this matter. State the reference.
It's
Yes.
November first week.
November, first week November.
Diplo.
My lord, my lord,
November.
in item number 36, my lord. Today's news, we are receiving the counter objection on yesterday, my lord. So we want to find the reason for what. My lord,
36.
yes, ma'am.
You are for the,
I am for the petitioner. Union Bank of India on behalf of Mr. Tunas.
you received the counter affidavit yesterday.
Yesterday, yes, ma'am.
So are you proposing to file any return
Yes, ma'am.
affidavit?
Yes.
Who is for the other side? Alok Kumar
Alok
Das.
Kumar Das.
Have you informed that,
My senior has informed me.
what is your name?
My name is Girish Kumar Sundar Rai.
Huh?
Girish Kumar Sundar Rai.
You have no power in this case?
On behalf of my lord.
You are mentioning on behalf of Tuna Sahu?
Yes, ma'am.
Not all. Submit on behalf of Tuna Sahu and counsel for the petition that the counter affidavit has been received yesterday and the rejoinder affidavit is required to be filed and the more time will be, the matter may be taken up some other day. Are you any interim order has been passed?
Yes, my lord. Interim order, my lord.
It is further stated, Mr. Tuna Sahu has received Mr. Alok Kumar Das, land counsel for the respondent about taking adjournment to file rejoinder affidavit. Put up this matter on the November 1st week of the interim order dated order dated 8/9/2025, passed in IA number such and such shall continue till next session.
Obliged.
Like, pardon, my lord, I think
The rejoinder affidavit is being filed in the meantime, serving a copy on the land council for this one. Yes.
Pardon, my lord, I'm mentioning is there, my lord, it concerns a pensionary benefit of for helpers, my lord, for
That is allowed over.
my lord, item 34, my lord. Item 34. On behalf of Mr. D.N. Mishra, I pay, for opinion number 2, I pay 2 weeks time for filing counter by
34.
34.
You are mentioning on whose behalf?
On behalf of Mr. D.N. Mishra,
GN Mishra.
my
DN.
DN Mishra.
D.N. Mishra.
He appeared,
OP number 2, my lord, Reserve Bank of India.
OP number 2.
My lord,
Number 2 तो लिखा है ombudsman.
my lord, Reserve Bank of India.
You have got power in this case.
No, my lord.
What is your name?
Amarendra Swai.
Yon Pranab. You want to appearing on behalf of Mr. D.N. Mishra Advocate and counsel for the opposite party number 2 submits that some more time is required to file the counter affidavit. And that the matter may be adjourned to some other date, court of this matter in November 1st. You intimate Mr. Amitabh
My
Tripathi.
lord, already intimated.
Have you intimated?
My senior already intimated.
It is stated that Mr. D.N. Mishra has already intimated and for seeking adjournment to Mr. Amitabh Tripathi, Land Counsel for the petition. All right.
Okay.
Supplementary list, item number 2.
Lord, we have, I am appealing for the corporation. Yesterday we have filed a reply. So the reply has not come on record, my lord.
Corporation one,
This is OHRDC, my lord.
acha.
So,
Opposite party number
one.
1.
So your lordship has
Just a
allowed.
minute, who is appearing for the petitioner? Who is appearing for the 2 and 3? There are
Interveners for one year.
2 and 3 are intervener.
No.
Who is LIC Housing Finance Limited
And another is builder.
and 3 is Mr.
Builder.
Mr. Sarthak. They have already entered appearance or not?
This is a disposed of case. A disposed of-
Is it disposal case?
Miller. We have filed a petition.
Just a minute. Disposal of case. Last year,
So they have
Recall.
filed
Recall of the order.
recall of the order.
23 2018.
18.
Maintain.
Lord, may I make a submission, my lord? But I seek your lordship's permission to make a submission on the preliminary objection. Will your lordship permit me?
Who has filed this interim appeal?
The board has filed.
So what further you want?
We have already filed a reply, but the reply has
Reply
not.
means?
Reply means they have filed an additional affidavit to that.
No, the interim application.
Your lordship
It
kindly-
is your application. So have they filed any objection to
Yes,
that?
sir.
Also?
They have filed an objection.
Okay.
And that in objection to that, I have last time took time and we have filed the reply yesterday, but it has not come on record, which is to be heard today. So that is why lordship may take day after tomorrow or
Have you
any.
served copy?
Yesterday I have served the copy, Lord, but it has not
Day
come.
after tomorrow you get ready.
Day after tomorrow the matter.
Look on.
Lord, I only pray, my lord, before your lordship, subject to your lordship constitution.
No,
Before-
that is not on record.
No, no,
Yes,
before your lordship proceeds, I may be permitted day after tomorrow,
yeah.
permitted to submit on the question preliminary objection.
Maintainability.
Next name, all right.
We have two decisions on
The
that.
IN number, just a minute. IN number is 5672. What is it?
IN number 5672 of 2000.
2018.
5672 of 2018. Is an application filed by the opposite party number 1, Orissa Rural Housing and Development Corporation Limited, for recalling the order dated 23/2018, passed in this case number 3675 of 2018. Stop. It appears that the petitioners to the writ petition have already filed their. What you have filed, Mr. Mohanty?
Lord, initially they filed the petition for recall. I filed a counter affidavit,
Acha.
filed a rejoinder. Thereafter, Lord, it is going on
In
and
the application, what so many.
and in the disposed of. That is squarely
So we
covered.
have already filed detailed reply to the additional affidavit saying how fraud has been
All right, all right.
perpetrated.
The I
Fraud. Let us see, is there any word fraud?
Yeah, interim application, it
But-
appears that, just a minute, that the petitioners to the writ petition disposed of writ petition, have filed counter affidavit to the interim application. And ତାପରେ ପୁଣି କଣ ହେଇଛି?
ତାପରେ ସିଏ ଗୋଟେ ଫାଇଲ କଲେ,
କଣ ପୁଣି ଫାଇଲ କଲେ?
That is
replied
Reply to the counter.
counter. Then another additional affidavit they filed.
So that reply we
I
have.
mean, disposed of matters, why so much of?
Miller, I will satisfy your lordship in the next.
Then there is a lot of factual dispute.
Yes,
If
factual
there is a
dispute.
factual dispute, why should we get into?
No, factual dispute with how they have connived and then
That
made
is,
the order. That is a compromise.
If
Miller,
we distinctly remember, if
Hmm.
so much of factual dispute is concerned, and if you say there is a fraud, then the remedy is to file a suit, not.
Yeah, exactly,
an
Miller.
application.
That is
Because
exactly.
you have to plead fraud and prove it out.
Yeah, next time I will say that how it has been connivingly taken and what is their right title interest, what is the right title interest of the corporation, everything on the day after tomorrow.
Yeah,
your
that's
lordship,
right.
thereafter,
Whether
you
we
will have
have
to
application when we can get into all this thing or not.
No, Miller, we have just said if it is fraudulently been taken, any compromise has been made,
We are
it is settled principle of law.
affidavit ପରେ
Miller.
IE ର ତାପରେ ଆପଣ କଣ ଫାଇଲ କଲେ?
ଗୋଟେ ଫାଇଲ କଲେ କାଉଣ୍ଟର ଆଫିଡେଭିଟ କଲେ ଗୋଟେ ଆଫିଡେଭିଟ ଫାଇଲ କଲେ
କଣ affidavit? କଣ ସେଟା?
that they will comply with the order.
କାହିଁ ସେଟା?
Affidavit filed 30/9/19 30/9/19.
That is additional affidavit on behalf of.
No, it is styled as at
ତାପରେ ପୁଣି ଅନ୍ୟ IE ସବୁ ଫାଇଲ ହେଇଯାଇଛି। ମାନେ this is a IE of 2018
18.
ତାପରେ ପୁଣି ଗୋଟେ IE ଫାଇଲ ହେଇଛି 2025 ରେ ଗୋଟେ କଣ IE?
That's similar
Sir,
intervenor.
that is intervenor.
Intervenor in disposed of case in a recall petition.
Just a minute, since we are mentioning all these things, IE ଟାକୁ ଆସ ସେ ଯୋଉଟା ଲିଷ୍ଟ ହେଇଛି 5672 ଆଚ୍ଛା ତାପରେ କାଉଣ୍ଟର ଫାଇଲ ଟେ ହେଇଗଲା ଏ IE and then the opposite party number 1 has filed
30/9
କଣ ସେଟା style?
It has styled as compliance affidavit
ଆଚ୍ଛା filed a compliance affidavit on 39
2019.
ଲେଖିନ ରଖ ସେଟା ତ ବାହାର କରିବ ଲେଖିଲ କଣ ଲେଖିଲ ତମକୁ କହୁଛି ପରା ଲେଖିବା ପାଇଁ କାଗଜରେ କୁହନ୍ତୁ
30/9/2019.
30/9/2019 ତାପରେ କଣ ହେଲା?
Then again they filed and this was done by one person, all these affidavits. Then in 25, another additional affidavit was filed by the subsequent incumbent in the office, not the author of that affidavit or compromise, by a subsequent person on 7/3/25,
Then
singing a different song which was not there earlier.
another additional affidavit was filed on behalf of opposite party number 1 on
7/3/25, 7 years after.
আচ্ছা তারপরে
Our reply to the board.
In
We gave the reply to this fresh affidavit.
additional affidavit or reply ଗୋଟେ ଦେଇଛନ୍ତି ସେଟା କାହିଁ
That is
ସେଟା ଲେଖାହେଇଛନ୍ତି ଆପଣ
ସେଟା ଆମେ ଦେଇଛୁ।
ହଁ ଲେଖା ହେଇଛି counter affidavit filed by petitioner ସେଇଗୁଡାକ then the petitioners filed a counter affidavit to the additional affidavit dated 7/3/2025 on 6/9/2025 ତାପରେ କଣ ହେଲା?
we have filed a reply, which has not common.
The Learning Council for the opposite party number 1 submits that a reply has been filed to the counter affidavit filed by the petitioners, but the same is not on record, though the copy of the same has been served on the Learning Council for the petitioners. Matter be listed on 17th of October 2025 with the reply filed by the opposite party number 1 to the counter affidavit filed by the petitioners on dated 6/9/2025. ହେଲା ସବୁ ଗୁଡାକ ସିରିୟଲି କରିକି ଇଏ କରିବ।
Why don't you prepare a compilation and give
We will file.
day after? We give instead of we will keep on searching.
Then we will file a complaint.
Prepare compilation to
Miller,
sets.
convenient chart, convenient
Take it
chart.
No, not chart. Your lordship wants the compilation. I will prepare it. I will prepare it. I'll prepare it and give it.
Instead of searching.
Yes, all these,
Installation of
right,
all
starting from the writ petition, order second.
by the parties by on the next day.
Compile.
That has not been record. I filed intervention. May I pray your lordship can be.
Hmm?
I have also filed.
Dispose of here and intervention.
Disposed of case, recall the intervention.
Yes, next.
Should I,
Hear you on that.
should I give your lordship those two decisions, not the placed on record?
Compilation ର ସବୁ ତଳେ ଲଗେଇ ଦିଅନ୍ତୁ.
ଆଚ୍ଛା।
So that easy ହେଇଯିବ.
ठीक
My IMA will listed, my lord.
है।
ଆପଣଙ୍କର IFP କେତେ ନମ୍ବର ଥିଲା?
18361 of 25. That was not listed on the board. 18361 of 25.
Defect cured.
My lord.
Defect cured. Any defects may be there.
Defect.
That's the reason it's not.
Then I have defect.
17983.
17983. That was more of the 18361.
17983 is there. That is there. 17983.
ଏଠିକି ଦେଖାଇ
It is 17983. It's there. already.
ଅଛି ତ ଅଛି ରେକର୍ଡ ମୋର
18361 ଟା ନାହିଁ.
ଅଛି ରେକର୍ଡ ଅଛି 17983 ଟା ଅଛି ପୁଣି କଣ
998 ମୋର ହଉଛି 18361/25. That was
ଆଉ ଗୋଟା ଇଏ ଇଣ୍ଟରଭେନସନ
man.
Three key entry.
it is stated that one interim application
You are appearing in person.
My advocate.
That his application is different. It is his application.
ଆଉ ଗୋଟେ
See you. file.
କେବେ ଫାଇଲ କରିଛନ୍ତି ନା ନମ୍ବର
Mr.
କେତେ ଟିପିକିଂ ଦିନ ସବମିଟ୍ସ ଆଉ ଇଏ ଫାଇଲ କରିଛନ୍ତି ଆଡଭୋକେଟ ସବୁ ଦେଇ ଦିଅନ୍ତି
Again.
want to submit that he has filed an interim application for intervention which has been registered as IA number so and so, their number, copy of which has been served on the land council for the other side. ଦେଇଛନ୍ତି copy ଦେଇଛନ୍ତି
Again.
the said IA be also placed on 17th 10/2025.
I'll prepare a compilation.
ଆପଣଙ୍କର ଆଇ ଅଛି
Item 3.
Yeah. On the last date, this honorable court asked me whether the present petitioner has filed the delay of condon petition before the filing the review petition. My lord. As per the information inadvertently that has not been filed, and in review petition, the learned tribunal has ordered at annexure 26, my lord.
You come to the order which we passed on that day, 22/9/2025. ସେଟା ବାହାର କରିଥିଲି 22/9/2025 ର ଅର୍ଡରଟା ବାହାର କର
My lord. Item 3.
Your review petition was dismissed on the ground of delay. You have not,
Let's
we have asked whether you moved an application for condonation of delay. You said now there is no application.
No, my lord, as instruction, no application. But in the instant case, my lord, only the point is the impugned order at annexure 1 is that the present opposite party, who is the applicant before that, he is promoted in the year
No, we'll
2024.
not go to that. You see, you have filed a review petition
My lord.
and since the delay condonation application was not filed and it was time barred, that is how the review petition was dismissed.
On the ground of delay and laches.
My lord,
What to do?
therefore
have-
that has been.
You see, at the first juncture, you could have directly approached this court against the order passed by the Central Administrative Tribunal.
Right.
You choose to prefer a review petition. You thought that there are some points which can be considered, but when that is time barred, you did not file any application for condonation of delay. So,
My lord, my humble submission
what
that.
you could have done.
My humble submission that review petition where it is filed before the learned tribunal, my lord,
There is a time period.
it is only stated in that review petition that since by virtue of the Honorable High Court's order, Delhi High Court order, there is a panel in the year 2018, and on the ground on which basis the present applicant was directed to promote in the calendar vacancy of 2013.
We are not on that. Review petition upon jo file kale, review petition file karibaro Central Administrative Tribunal procedure on jai, it is laid down that within what
30 days it should be.
So obviously you have not filed
My lord.
the review petition.
My lord.
That also says a boy.
My lord, 30 days ভিতরে হবা কথা, that has not
Rule
been done.
13 cases.
Only problem is that, my lord, it is the promotion is of.
No application for review shall be entertained unless it is filed within 30 days from the date of receipt of the copy of the order. A review application shall ordinarily be heard so and so. An application for review so and so, no application for review shall be entertained unless it is supported by so and so. The time limit is fixed, but if you file it after the period of 1 month, then you are supposed to file that application for.
My lord,
And you should have shown sufficient.
my lord,
grounds.
my lord, my humble submission to that respect, my lord. It has not inadvertently that is the conducting council is not filed and the officers are not aware about that whether delay is filed. Only problem is that, my lord, the promotion.
Inadvertent errors of an individual lawyer can be condoned, not the Union of India.
No, my lord, only problem is that, my lord, the impugned order passed on the basis that since his junior is promoted in the year of 2013, so he directed to that. But as per the Honorable High Courts of this Delhi High Court at Annexure 3, my lord,
Where is your
the officers, my lord, review application at page that is Annexure 26, my lord. And my lord 25, sorry, 26 is the review order. And in that case, my lord, the specific ground.
You see, so many grounds you have also taken in that review petition.
Sir, review petition ne amar main ground ta hochi mu padi dochi seta.
No, pochi ame dekh saluni. Review petition ne you have taken so many grounds. So you thought that this is a fit case where review petition not only to be filed, but if these are to be considered, then the earlier order which has been passed that is likely to be interfered with. So taking all these things once you are filing the review petition, then and it is at a belated stage and 30 days is required for filing. So question is that we are asking you again that same question, that why if you file a review petition and it was the beyond 30 days period, why you did not file the delay condonation application explaining the delay, so that he could have condone the delay and could have entertained the review petition and decided the review petition on merit. That is our question.
My lord, but my humble submission, my lord, that has not been filed and that has been rejected in review applications. Only problem is that the Honorable High Courts, by virtue of the Honorable High Court's order of the Delhi High Court, that is Annexure 3 also in writ petitions, I have also separate copy, my lord. For that, the claim of the opposite party that his junior is in the year of 2000, that has been changed, my lord. So he is senior and also he is junior in the year of 2014. So that therefore that is the review application. Suppose, my lord, we will not. So, my lord, your liberty may be given to me to file the review petition with the delay on this ground and also. So it is the legal point. Otherwise, the havoc, because so many multiply cases will be arised as because of if he will be promoted in the year. He is promoted, my lord. That is only difference, that he is promoted in the year of 2014 vacancies. He is claim that I will be promoted in the vacancy of year of 2013 as because my junior is promoted at serial number 8. That has been changed. Subsequent panel in pursuance to the Honorable High Court's order of the Delhi High Court, my lord. That has been annexed at Annexure 3. And already.
Okay, have you explained anything in this writ petition that why there was delay in filing the review petition? Let us say that you have not filed there, because you want now that it may go again to the Central Administrative Tribunal for considering the review application. And so that you will file an application for condonation of delay, so that if it is condoned, then your review petition will be hard on merit, right? So for that, we must also, at least you should point out here that these are the reasons for which the review petition could not be referred within time.
May
What
we
is your-
explain it in the writ petition? The cause of delay.
Review petition is
ଆପଣ
annexed
ଯୋଉ
for
ଜିନିଷଟା ଚାହୁଁଛନ୍ତି ଆମେ ତ ପୁଣି ରିମାଣ୍ଡ କରିବୁ ମ୍ୟାଟର ଗୋଟେ ଜଷ୍ଟିଫିକେସନ ଦବୁ
my lord, my lord. No, no. Yes.
Is it your case that limitation doesn't apply to Union of India?
No, no,
That
limitation.
you will not explain to the CAT, you will not explain here, and it should be condoned, promoto.
ମେକାନିକାଲି ସବୁ ହେଇଯିବ ଆପଣ ପାଇଁ since you are Union of India, so delay applicable ହବନି.
At least in the writ petition, you should have said that these are the reasons for which we could not file the review petition in time.
And also inadvertently we could not file any application.
Somewhere whisper in the writ petition.
My lord, in para.
ଆପଣ ବର୍ତ୍ତମାନ ସେଇ ପ୍ରିୟାଟାକୁ କରୁଛନ୍ତି ଯେ ମୋ କେସଟାକୁ ସେଠି ପଠେଇ ଦିଆଯାଉ ରିଭ୍ୟୁ ପିଟିସନଟା ଶୁଣାଣି ହବ with the delay condonation application. ତ ତା ପାଇଁ କିଛି ଗ୍ରାଉଣ୍ଡ ଦିଅନ୍ତୁ.
That prayer is also made on the prompting.
No, 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 my lord, I am not hearing because no, I'm because since earlier while I'm filing the writ petition, I have annexed 20.
କରିନାହାନ୍ତି ଆପଣ ଥରେ ତ ଅଲରେଡି ଆମେଣ୍ଡେଡ ଫାଇଲ କରିସାରିଲେଣି ଆଉ ଥରେ ଫାଇଲ କରନ୍ତୁ ଆପଣ ଏଇଟା ବୋଧେ ଆମେଣ୍ଡମେଣ୍ଟ ଫାଇଲ କରିଛନ୍ତି ନା କନସୋଲିଡେଟେଡ
Sir, ସେଇଟା amendment ମୁଁ କରିଥିଲି annex 26 କରିଥିଲି inadvertently that
ମାନେ ତ ଆପଣ ପୁଣି କିଛି ଆଉ ଜାଣିଲେ ତ କଣ କରିବାକୁ
ଆଜ୍ଞା,
ଅଛି
ଆଜ୍ଞା.
ଆପଣ ଯୋଉ
But I will explain and amend the
କେତେ ହିଣ୍ଟସ ଦିଆଯିବ ଆପଣଙ୍କୁ
CAT ବି already contempt କରିଛି.
Having that decision which says that if there is a delay in filing a review petition, then that can be condoned on that showing the sufficient results.
I have to verify my lord. I have to verify ବୋଲି ଜାଣିଛନ୍ତି ବୋଲି ପଚାରୁଛନ୍ତି ଆପଣ. ଅଛି ଟିକେ ଦେଖିବାକୁ ପଡ଼ିବ ମୁଁ ଜାଣିନି ରିକଲ୍ କରିନି.
There is no pleading, there is no law, nothing there.
There is no power.
My lord,
Let us say.
my lord. My lord.
So then entire thing goes. You start in that line. The land council for the simple adjourn कर दूं जी केबे रखिवा कौन
Next week.
MK Pati land council
Next
to
week,
government
my
council.
lord, only next week as my lord, but they are proceeding in contempt matters.
नहीं सेगुड़ा काम किछ
What content? Already he has been promoted.
My lord, he is promoted to 2000.
It's all right, promoted up.
No, contempt କରିଛନ୍ତି ନହେଲେ ଆସିଗଲେ this is the order.
We
my lord.
dismiss this writ petition now that now this put up this matter next week this.
Next week, my lord, I will file the amendment.
फाइल करियो आपण जान डिस्कशन बहुत ही गराने आ बेसी डिस्कशन करिया उची. Yes, next.
Item 5.
Next week.
My lord, the petitioner challenging the laws passed by this learned Central Administrative Tribunal, Kotak, on 14/1/2025, on page number 146, my lord,
100,
46.
142. 6.
My lord. This order was passed on 14/1/2025. Well, they have concluded,
No, what was the prayer made?
well, this matter, this order may be quashed.
What was the prayer made before the Land and Central Administrative Tribunal in the original application?
Original application.
Have you filed the OA copy?
Yes, my lord.
What is the that relief sought for? Page number?
Well, documented. Well, I'll come to the page 53.
Hold on.
In view of the fact stated in paragraph 4 about the applicant pair for the following relief. The physical efficiency test criteria in column number 8.6 under annexure A by 1 as declared inoperative and invalid so far as the land user candidates are concerned, and it may be further declared that the applicant.
1 minute. This I can't hear this. I can't hear this. I was a lawyer for.
The put of this matter.
In
Put
applicable.
in one of possible speak not advantages.
Item 6.
May I please, my lord? Well, the order of the grievance redressal forum, my lord, under annexure 6 at page 41 has been challenged. My lord, the facts are like this. This OP number 1 is a consumer of electricity under the distribution company NESCO. And my lord, he has executed an agreement on by the annexure 1 in 1995 to draw power for a contract demand of 57 kilowatt. Then, my lord, subsequently he went on drawing power more than 57 kilowatt. That I have stated, my lord, in my paragraph, my lord, that to the extent of, my lord, 57 kilowatt, which was subsequently, my lord, exceeded to 74 kilowatt, and thereafter, my lord, it was exceeded to 96 kilowatt, and billing was continued under 96 kilowatt, my lord. And subsequently, what happened, my lord, the consumer in 2010, my lord, exceeded the limit of that medium category, which is up to 99 kilowatt. When he exceeded the consumption of drawal of excess load, my lord, by the annexure, we issued a notice was issued, my lord, demanding to be billed under large industrial tariff, and demand was made for additional security, my lord. My lord, challenging that, my lord, that notice is under annexure 2 at page 19, my lord. That he was called upon to execute a fresh agreement and to deposit the security deposit.
What is
Additional
this
security
writ petition pending?
My lord.
There is a reference to a writ petition pending before.
No, my lord. My lord, it's challenging this notice under annexure 2, my lord, where he was called upon to execute the fresh agreement under large industrial tariff and to pay the additional security for regulation of the load, my lord. He preferred a writ petition by the annexure 3, my lord, which was disposed of by order of this honorable court, that is writ petition number 18848/2021, disposed disposed upon 14/5/2024, my lord. After a long lapse of time, my lord, the petitioner in that writ petition prayed for to approach the grievance redressal forum. Accordingly, the honorable court was pleased to dispose the writ petition, granting liberty to the petitioner to prefer writ petition. Approach the grievance redressal forum. Accordingly, by the annexure 4, my lord, he preferred a complaint before the GRF, my lord. And the GRF, my lord, has passed the order, the operative portion, Lord, may kindly see at page 56, my lord. The last order is, my lord, from the top I am reading. After giving some observations, my lord, in view of the above, we hold that the opposite party.
Where are you reading?
My lord, 56 top.
Page 56, running page 56 from the top. Observation one paragraph, then I will go to the other question. In view of the above, we hold that the opposite party should bill the consumer as per the medium industry tariff with charge of overall penalty for the excess drawal of power beyond the CD but below 110 kVA, and for the month in which the contra demand exceeds more than 110 kVA, in such months the consumer should be billed as per tariff large industry. This is absolutely contrary to the regulation as well as the tariff order of OES. Once your contract demand exceeds, your drawal of power exceeds the contract demand, and under what category it falls, you are to be billed treated as a consumer under that category. When
even if it's only 1 month, that will be done.
No, in this case, 11 occasions he has drawn powers constantly. The GRF has observed, Lordson, have a glance to paragraph GRF order, page 53. Last but one line, last from top bottom to 7-8 line, I am reading. The opposite party disconnected the line on 15/7/11 for a failure to execute fresh agreement and reconnected the same at the instruction of the Honorable High Court on 19/7/11. The MDI is maximum demand indicator. The meter indicates how much power he draws in a particular month. Where again, from the bottom,
Page 53.
Page 53.
The opposite party
12th,
disconnected the line
from bottom from 12th line.
15/7/20.
The opposite party disconnected the line on 15/7/21 for failure to execute the fresh agreement and reconnected the same at the instruction of the Honorable High Court on 19/7/11. The MDI were again jumped to 110 kVA in 6/2011, in 7/2011 114, 119 kVA in 8/2011. Like this, this is 11 instances, he has indicated, and this is also not disputed that actually he has done this much of power for which
110 is the
yes limit, and he has exceeded beyond that, for which he comes under the large industrial tariff category as per regulation 80 .
MDA, the full form for
Maximum demand indicator. So far this industry is
demand
indicator. And one energy meter is there to record the consumption, and a demand meter is there for the purpose of a calculation of MMFC. We pay the MMFC month-wise fixed charge, and so far the industries are concerned, they
He
are
will
to
come, according to you, he will come under the large category.
yes,
Large category.
large
Not
industry.
medium category.
That is why the notice was issued by the Annexure 1 to execute the fresh agreement under that category.
But
He
the
did not return, came to High Court. And
but he says that whenever he crosses 110, you charge in large category.
we will
If it
issue
is
notice.
lesser than that,
We
then
will
in
issue
the
notice,
medium category.
will issue notice, then he has to come whether he will execute or not, give sufficient explanation. And in this case, he did not come forward to execute the agreement, And
For large category.
large category. And he also did not deposit the additional security. And by filing the writ petition, matter continued for years together.
What is the difference? Tariff difference?
Tariff difference, so far this category industry is concerned, he will pay a demand charge. They are covered under 3-part tariff. One is customer service charges, other one is demand charges. Whatever power, suppose contract demand is 110 kVA, 110 kVA into 250 is the demand charge per month, and energy charges. Whatever consumption will be recorded in the energy meter, as per the tariff rate, he has to pay the charges.
Substantial difference.
And so far the domestic consumers are concerned, we are paying for per kilowatt 20 rupees plus additional kilowatt 10 rupees and plus energy consumption. We are covered under 2-part tariff, and so far this industrial consumers are concerned, they are covered under 3-part tariff. Here, though overdrawal of power is admitted beyond the contract demand, the GRF has said, जो period से exceed करची ताको सही period
large करो, medium करो.
जोटा नको सेम सर provision किसी नहीं ORC तारीख वाला सेटा नहीं. एवं सर आउ गोटे कथा होती है most interesting is ये थोड़े
electricity user pay less than other consumers.
As per the Sitaram rice mill case, once the consumer violates the regulation, 103, 106, out of 660 consumer, if he wants to enhance the contract demand, following regulation 66, 72, he has to make an application for enhancement of contract demand. Here he has violated the regulation, he has not applied
and went on from the very beginning, my lord, in 1995, she went on availing power supply beyond the contract demand. And when notice was issued, it did not turn up, my lord. And when, as per Sitaram Rice Mill case, if the consumer violates the regulation, he is to be billed as per regulation 126, my lord. That is penalty, my lord. My lord, your Honorable Supreme Court has said, when the consumer is in breach of the contract, is to be penalty is justified under 126 will come into
Let us keep it simple now. We will issue notice, thereafter all regulation and everything will be discussed.
And
This petition has been filed by the executive engineer elected TPNODL, Bhadrak North Electrical Division, Bhadrak, challenging the order
penal part of
7/8/2024 passed by the grievance redressal forum in case number 157 of 2024. It appears that the opposite party number 1, Mr. Sri Vijay Ice Plant, filed the complaint before the GRF. What was his prayer? Where is that, Tara?
my lord. Prayer is, my lord, at page 44, my lord.
44.
My lord. Respondents communication
Just a
related
minute.
page 44.
With the prayer as follows, for example, page 44 report is a prayer. The after issuance of notice, the petitioner filed the counter affidavit, and the London GRF, after considering the pleading and hearing the land council for the opposite party number 1 also filed the rejoinder, the counter affidavit filed by the petitioner. Going through the pleadings and hearing the land council for the so has been pleased to hold that
56.
Pleased to direct the petitioner to bill the opposite party number 1 as per medium industrial category, bracket LT/ST industrial bracket M, with charge of overdrawal penalty for excess drawal of power beyond city but below 110 kVA, and bill the months in which the contract demand exceeds more than 110 kVA as per the tariffs of large industry, and also to execute a fresh agreement for the enhanced load, and to withdraw the proportionate DPS as per the above revisions. The Land Council for the petitioner, Mr. Das, submits that admittedly on 11 occasions, on 11 occasions, the opposite party number 1 jumped to 110.
Jumped MDIs.
Beyond the maximum demand indicator limit, which is fixed to 110.
110 kVA is the limit.
110.
Above that is
kVA.
large industry. Coming to large pole.
And thus the opposite party comes under the
large industrial tariff.
Large industry.
Industrial tariff category.
Large industrial tariff category. And the same would be evident from the input order itself. And there is no such provision in the
either in the regulation or in the tariff order provisions.
Either in the regulation or in the tariff that a person like the opposite party number or an industry like the opposite party number 1 who crosses the maximum demand indicator on 11 occasions should be charged with
In terms of
in terms of the order that has been pronounced, which is illegal and not sustainable in the eye of law. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. No notice be issued to opposite party number requisites for issuance of notice on opposite party number 1 as proof of delivery be filed during course of this week. Matter be placed on such and such day.
not interim stay, I said, for this improved order.
Interim order ତାଙ୍କୁ ତ କହିଛନ୍ତି ଆପଣ ଏଇ ଯୋଉ ଇଏଟା ଏଗ୍ରିମେଣ୍ଟ କରିବା ପାଇଁ ସେଗୁଡା ଷ୍ଟେ କରିବେ
ଆଗ୍ରିମେଣ୍ଟ ସେ କହିଛନ୍ତି ଯାର ଆଗ୍ରିମେଣ୍ଟ କରିବ ଏବଂ ଯୋଉ ପିରିୟଡ ଟା ଏମଆଇ ରେ କରିବ
had
ଯୋଉ ପିରିୟଡ ଲାର୍ଜ ଏଣ୍ଟ୍ରି କରିବ ସେଗୁଡା କହିଛନ୍ତି
No interim order can be passed. What needs?
ସାର୍ ଏଇଟା ଷ୍ଟେ ହେଲେ କଣ ଆମେ ତ ସେମିତି ଅଛି ଆଜି ପର୍ଯ୍ୟନ୍ତ ଏଇଟା ଜିଆର ପଡ଼ଟା ରହିବ ସେମିତି ରହିଲେ ଆପଣ ବିଚାର କରିବେ ଯାହା ହବ
କଣ ହବ
ଜିଆର
କଣ
ପଡ଼
ଲାଭଟା କଣ ହବ
ସାର୍ ଏଇ ଯୋଉଟା କହିଛନ୍ତି ସେ ପାର୍ଟ ଏମିତି କରିବାକୁ ଏଇଟା ଦ୍ୟାଟ୍ ମେ ନଟ୍ ବି ଡନ୍ ଆଟ୍ ଆୱାର ଏଣ୍ଡ ମିଲର we are also not charging DPS or any amount on the consumer because in the meantime he has also moved the OERC for implementation of the order. There has been delay in listing of this case, Miller. He has moved the OERC.
Insisting for implementation.
Recently.
IR number so and so, the application for stay of the operation of the order dated so and so, passed by the GRF Balaso. After going through the grounds taken in the interim application and hearing Mr. Das, let there be stay of operation of this transfer until further orders is.
Item 7.
Item 7, my lord, there is a matter relating to other cases. The numbers are provided by my lord associates, Mr. Shah and there is 3 another cases 215666 20415 23042 of 2025. Out of the same issue that has might have pushed it to 27th.
No, Mr. Paddy, there are 2 cases before us today.
And another 3 connecting matters are similar in nature and it was posted to 27th. All the 3 make only 1 case is left. Yes. 2 cases before my lord. 1 case is left. It was posted to 27th.
Appointment widow is seeking the compassionate appointment and the rejection order is that since your husband was regularized by virtue of court's order, you cannot be
If you
considered.
want to hear this, according to my
That is
friend
the
wants to
reason they
hear
have
it, then
rejected
you will
blood and
proceed
the
with
law and
it.
tribunal set aside.
In all the cases. In all the cases.
All cases, all 3 cases, rejection order is only on the ground since your husband was regularized by virtue of court's order, therefore your case cannot be considered for compassionate
Not
appointment.
exact, not
And the law and tribunal
We'll do
has
a
set
very
aside that
good
order
hearing,
and
no.
remanded back to the authority for consideration. And we are widow Miller.
So, in an age of 23042 ta, eta, are you disputing that it is similar matter?
Similar Miller.
তাহলে সেটা তো ফিক্স অফ হয়েছে 27/10/2025 কু
If your lordship
এবং
will
তাদের
dispute of these 2 also, that will cover that matter.
তাদের অর্ডার হয়েছে যে তাদের অর্ডার হয়েছে যে এই সেটা শোনা হবো এই 2টা ম্যাটার হইতে সেটা অলরেডি যে জুডিশিয়াল অর্ডার
That's why I'm submitting my lord.
Press admission.
ଅଛି ତ admission
ନାଇଁ ସେଇଟା ତଳକୁ ଲିଷ୍ଟ ହେଇଯାଇଥିଲା ପୂର୍ବଟା ମୁଁ ଦେଖିଲି ତଳକୁ ଲିଷ୍ଟ ହେଇଯାଇଥିଲା ତେଣୁ କହିଲା
ନାଇଁ ନାଇଁ ଏଇଟା ୱିଥ୍ ହେଇକିନା ଆସିଗଲେ ଏ ନମ୍ବର ଗୁଡାକ ଉପରକୁ ପଳେଇ ଆସିବ ଯୋଉଗୁଡାକ ଅଛି ସେଗୁଡା ଏଇ ଗୋଟେ ନମ୍ବର ନା ଆଉ କଣ କୁହନ୍ତୁ
23,000
Only 3.
ଆଚ୍ଛା
only 3 cases.
ମିଷ୍ଟର
Ground of rejection, sir.
Pari and Deputy Solicitor General appearing to virtual mode with Kahana Lekha Voti.
In first case, Amit Kumar Saman.
Faster,
Second case, I'm happy giving.
Faster Swansu and Swansu submits that there is a connected matter that is WPC number 23042 of 2025, which was directed to be heard along with the present writ petition. And the said case is posted to 27/10/2025, and therefore this matter may be listed along with so and so.
In the second matter, Mr. D.V. Mishra is appearing.
Put up this matter on 27/10/2025 with WPC number 23042 of 2025 এটা প্রথমটা লিখবে and WPC number 20415 of 25 ଆଉ ତାପରେ ସେ WPC number 20415 ରେ ସେଟା ଲେଖିବେ that is to come with 23042 25 and 21566 of 25 ହେଲା clear ଆଉ advocate ଙ୍କ ନାଁଟା ଦେଇ ଦିଅନ୍ତୁ ସେ ଲେଖିଦେବେ
All three cases I have already entered appearance.
all right ନା ତ ଅଛି ଆଉ।
Item 8.
May I plead the lordship?
Yes.
In this case, my lord, I am challenging impugned order annexure 6, my lord. The judgment of the Central Administrative Tribunal, my lord. My challenging on the ground, my lord, that they have not issued me a pay fixation order. And at last, at the time of hearing, they have issued me a pay fixation, so-called pay fixation order, which is not genuine, my lord.
You come to the original application which was filed by you.
Yes, original application 214, my lord. I have filed. Yes, original application.
So the prayer which is
Relief short. Relief short.
the relief short formula and direct the respondent to release.
Issue PPO.
First direct the respondent to issue PPO.
Pension payment order.
Acha.
And next to direct the respondent to release pension discharge commuted value pension leave salary with 12% interest. And first thing, they have issued me the pension payment order after some amount in several transactions, 7 transactions, they already paid them. And then, my lord, they have issued a pension payment order. Here, my question is my prayer, only prayer. I may be issued pay fixation order, which they have issued in every case, my lord. In my center, where I have retired, my lord, that center, they have issued the pay fixation order after it order of regulation, my lord.
You come to the impugned order, then.
Impugned order, yes, my lord. Impugned order, next is 6, my lord.
Please come to paragraph number 6.
Paragraph number 6, yes, madam. We have considered the submission of the parties and perused the record. The consistent view of the apex court is granting relief not paid for the suit amounts to violation of principle of natural justice. And for the other side, therefore, the court and tribunal should maintain self-distance from granting the relief not specifically paid for the original suit, my lord. My lord, Acha. We find that force of the submission of the respondents counter that the prayer made in MA was not the prayer of the OL, and it is not in dispute that the applicant meanwhile has been issued PPO and granted other financial benefits as noted above. In view of the above, the OA does not survive, and therefore the different prayer MA filed by the applicant automatically falls through. From the facts furnished by the respondent, we find that the delay in disbursement was not intentional or deliberate on their part, but the examination of the record of this bench by which the applicant is entitled the benefit consequent upon regulation of her service. Hence, we are not inclined to improve. My lord, pay fixation order is the first basis, my lord, on which basis they have calculated my last paid run. And thereafter they will issue me a PPO, my lord. First they have issued, my lord.
That the prayer in the MA is completely different.
No, my lord. Prayer, extremely sorry.
ଆମେ ଦେଖିଲେ MA ର prayer ଟା ଦେଖିଲେ
Yes, madam.
ସେ ଯୋଉ କହୁଛନ୍ତି different ବୋଲି
And there will I have filed two different pay fixation order. I
And
have,
the real issue you try to concentrate.
my
The real issue is the tribunal says there is the prayer made in the MA is not the prayer in the OA. Therefore, the MOA is dismissed along with the OA. So therefore, there is no adjudication insofar as OA is concerned.
my lord, one thing, madam, I will be permitted to explain, my lord.
So my brother is asking you what is the prayer in OA, what is the prayer in MA.
Acha, MA.
So that
MA, therefore prays that the Honorable Tribunal please to admit the MA and after hearing the application order may kindly direct the respondent for necessary correction of the documents that the pay fixation order, salary due done statement, along with the people, other payment made to the applicant through her bank account. My lord, first they have remitted some amounts without any heads of accounts, my lord. Then they have filed, they have given me after 3 years of the remittance, they have filed with the PPO. PPO, how they will calculate, my lord, without pay fixation order? And in all cases, after retirement, they have filed first issue a pay fixation order, then they have filed a PPO, my lord, issue. In my case, that is reverse, just reverse, my lord. How they will calculate my salary last paid on?
and where is the prayer in the MA?
MA, yes, my lord, MA is
Page?
necessary correction of the documents.
is 90.
In the documents in the pay fixation order. Pay fixation order, they have issued me a fake pay fixation order. I should not say fake, that is not genuine.
This petition has been filed by Ms. Anupama Tripathi. Challenging the order dated 15/7/2025 passed by the Learning Central Administration Cutter Bench Cutter in way number 260
214.
00
214 months, 214.
260/00
Yes, yes, sir.
214 of 2023, bracket Miss case number 683 of 2025, in which both the original applications also the miscellaneous application were disposed of. On perusal of the impugned order, it appears that the miscellaneous application was considered by the Learned Tribunal, and it has been held that the prayer made in the MA was not the prayer in the OA. And since PPO pension payment order has been issued in favor of the petitioner, and she has been granted other financial benefit, therefore the OA does not survive.
Well, sorry, my lord. I will pardon to.
Observation.
Only 1 minute.
He has not been discharged, my lord. He has not been paid
1
discharged.
minute, madam, whatever is object.
Observation time.
Hold on.
You are.
Hold on.
Therefore, the OA does not survive, and since a different prayer has been made in the miscellaneous application, it automatically falls far. It has been further held that the delay in disbursement was not intentional or deliberate on the part of the authorities, and therefore the Learned Tribunal has been pleased to dispose of the OA as well as MA stock. Mrs. Rakhi Sikdar, Land Counsel, appearing for the petitioner, placed the prayer made in the original application, so also the miscellaneous application. For ready reference, we are quoting both the prayers. Where a prayer to quote kariye, which is at page number, you relief sort for achi. That achi page number huchi 6 rachi internal page paragraph huchi 8 rachi na. Apare semti miscellaneous application ta tar tole achi dekhive. ता prayer to quote कर दे, है ना? बेटा अच्छी running page अच्छी 90, है ना? तब quote करिए. You come to the now, ma'am. You come to the paragraph that relief sought for. You original application.
Original is
Paragraph 8 mo जो आपन को relief sought for original application. ଆସିଲେ ଆପଣ ପ୍ରଥମ prayer ଥିଲା to direct the respondent to issue PPO.
Yes, ma'am.
Right. The Learned Tribunal has been pleased to hold that the PPO has already been issued in your favor, whether it is a correct statement or not.
No, that is not correct. Because PPO will depend upon the pay fixation order, where his or her salary after retirement will be fixed as last pay drawn. They have not decided with that.
All right, look on. The Mrs. Sikdar submits that though it has been observed that PPO has been pension payment order has been issued in favor of the petitioner by the Learned Tribunal, which was also the prayer of the petitioner in the original application, but the same is factually incorrect, right? That is your submission.
Yes.
Come to the second prayer in the original application.
Direct the respondent to release the pension, discharge, and commuted value pension and leave salary. I have not been paid discharge.
Have you got these reliefs?
Other relief I have no.
No, you
With- Excepting discharge.
Accepting DCRC, everything she got.
Submits that so far as the second prayer in the original application is concerned, except the DCRG, the petitioner has got all other reliefs. Stop. And therefore, the observation made by the Learned Tribunal that since the petitioner that the petitioner has been granted all other financial benefits is also not factually correct, right? Stop. It is further argued that the prayer made in the miscellaneous application is not different in nature than the original application.
It is a consequential one.
And it is a consequential one, and therefore the impugned order is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. So, Mr. Pari, are you entering appearance for all the opposite parties or?
Yes,
notice-
yes. Yes, all the.
Deputy Solicitor General with Kahana.
SS Kashyap. SS Kashyap.
SS Kashyap. Land Central Government Council.
He's a senior panel counsel.
Senior Panel Council submits that they will appear for all the opposite parties. Let extra copies of the writ petition be served on the Land Council for the opposite parties during course of this week.
Yes, ma'am.
Put up this.
Maybe pardon to interfere, my lord. That 12% interest, they said that is not intentional. I said it is intentional because
No, that
order
should be-
was-
that
That is adjudicated.
That is disadvantage.
We are just giving
Yes.
hints that when issuing notice, we must show that what are the things that is telling, so that would be so that the court has found this prima facie point, so issuing the notice.
Yes.
So like this matter be listed 4 weeks for a court to counter affidavit if any to filed in the meantime. Yes. Next.
It will be better for 3 days. It's requisite not in course of the 3 days, madam.
In
It will be
course of
better.
the day, I'm a in course of this week.
Yes.
In
No
course
problem.
of this week.
Yes.
Item 9.
Well, here is a clear case of fraud and misrepresentation. The petitioner is the original owner of a cold storage unit and ice factory consisting of G+5 floors, situated.
What you are now praying for?
I'm challenging the order passed by the recovery officer rejecting my intervention application, Malats.
But or just see the order dated 22.
Yes, that's the previous order.
There was some observation.
Sir, brought the judgments, Malats, which says this writ petition can be entertained.
Regarding maintenance.
Yes, Malats. Any order passed by the recovery officer in its quasi-judicial capacity is amenable to writ jurisdiction. Malats, that is the order of our own High Court, Malats. Page 7, paragraph 9. Page 7. Paragraph 9.
Come to the conclusion. Yes, read.
Therefore, since we have come to a conclusion that the impugned order passed by the recovery officer is in his exercising of quasi-judicial functions, obviously a writ of certiorari is clearly maintainable. Apart from the above, the very judgment relied upon by the learned counsel for the opposite parties, that is the case of State of UP, bracketed Supra, the constitutional bench has categorically noted that the precondition for issue of mandamus do not apply to the writ of certiorari, and if the requisite grounds exist, certiorari would lie even after a right of appeal has been conferred by the statute.
No, but it may lie. There is no problem in maintainability. But what prevented you to go to the DRT? Why are you jumping? See, there are two jurisdictions. Writ jurisdiction cannot be taken away. Writ jurisdiction is there because quasi-judicial authority. But what prevented you to go to DRT against an order passed by a recovery officer? A recovery officer orders are being challenged in an MA in DRT. Why don't you go there? Why are you wasting time in the writ jurisdiction? You get one more forum. If any order is passed, again you can come. Why are you losing a forum?
Liberty may be given.
That's good because you get a forum. You can agitate better because we are not the court of facts, isn't it? We are the court of writ court. So better that you argue on facts. We'll give that liberty.
The delay may be condoned. The delay may be condoned.
You move appropriate application. Section 14 benefit you.
Yeah. Yes.
Though the Land and Council again placed reliance in the case of Govind Chandra Patnaik versus presiding officer, Debt Recovery Tribunal and others reported in 2009, Volume 2, Orissa Law Reviews 374, to show the maintainability of the writ petition against the impugned order dated 30/8/2025, passed by the recovery officer under Annexure 1. But during course of argument, he submits that since the order can also be challenged before the Land and DRT, permission may be granted to withdraw the writ petition to oppose the DRT. While filing such application, if any application for condonation of delay is filed, the same may be also directed to be considered favorably. Considering the submission made by the Land Council for the petitioner, the writ petition is permitted to be withdrawn, giving liberty to the petitioner to oppose the Land and DRT, and if any application is filed for confirmation of delay, it is expected that the guarantees shall consider this keeping in view the provision under section 14 of the limitation act. Yes, next.
That's grateful.
Item 10.
May I please, Your Lordship. My Lord, state this file, this writ application challenging the order passed by London Tribunal, Odisha Administrative Tribunal, that is at Annexure 1. The order dated 21/9/2017. The impugned order relevant to the operating portion of the order is at page 39. Keeping in view the principle as settled by the Honorable Apex Court in the case report, that is Rafik Masi case, to above, and as the letter by Annexure 6 and 7 has already been quashed by the tribunal, which order has already attained finality, the action of the respondent to recover the amount is illegal and not permissible. It may be stated that at the cost of reputation that as the impugned order has already been quashed in OA number 694C of 2011, the respondent authorities are directed not to take any action for recovery of the amount already paid pursuant to the letter, the said letter. This same order is also challenged before this honorable court, and this honorable court also rejected.
Messy judgment.
Rejected.
Messy.
Yes. Only 7-month differential.
And the same OA is there?
Same
OA.
Same order.
Which OA? OA number?
In the present case.
OA?
My lord, at serial number.
Give the OA number. Common judgment pass it.
এইটা ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ওଏ ନମ୍ବର 2944 ସି
My lord.
44C.
এইଟା ହଉଛି ଯୋଉଟା ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ବର୍ତ୍ତମାନ এইଟା ଆପଣଙ୍କର
2644C
କୋଉଠି ଲେଖା ହେଇଛି
cost title ରେ
ନାଇଁ ଏଇଟା ଯୋଉ ରେଫରେନ୍ସ ଦେଲେ
order ଟା ଦେଇଛି
ହଁ ସେଟା
that order
କୋड
ସେ ବ୍ୟାଚ୍ ଅଫ୍ କେସ୍ ଭିତରେ ଅଛି ଗୋଟେ
କୋଉଟା କୋड
ଦେଇଦେଉଛି
ରାଇଟ୍ ଦ୍ୟାଟ୍
ତା ଦେହରେ ସେଟା ଦାମୁ ମାଝି ବୋଲି ଜଣେ କିଏ
ଦାମୁ ମାଝି ନା
ଦାମୁ ମାଝିଟା ଦେଖିବାକୁ ଏଗୁଡା ସବୁ ଇଏ ଦାମୁ ମାଝିର ଓଏ ନମ୍ବର କେତେ
1650
ହଁ
1650
କୋଉଠି ଲେଖା ହେଇଛି ଦାମୁ ମାଝି କୋଉ ପେଜ 1650, right? That is in page number 27.
1650C.
Page number 21.
No, 27.
27.
27.
1650C up to
serial number 82 रे लिखा है दामू माजी 1056 ना এটা দেখতে দেবে challenge to answer and in which batch of to answer and this WPC was filed challenging the order dated say you common order date
same impugned order
same impugned order asked in OA number 1650C of 2010 in respect of Damu Maji है ना and this court has after considering the ratio let down in the case of one so Rafik Mas has been was not inclined to interfere with the order. No?
Why are you filing writ petitions?
Accordingly,
you need
to find no merits in this one. So,
wasting time.
Coverage observation that you to be open to the state government to so and so was made from that for the Celinter oil.
Once we upheld, they comply the order.
Both ଗୋଟେ order ହେଲା ଆଜି ଏଇଟା ଦ୍ୱିତୀୟ order ଆଉ କିଛି ଫାଇଲ କରିଛନ୍ତି ଯଦି କୁହନ୍ତୁ ତା ନମ୍ବର ଦେଇଛନ୍ତି ଏକାଠି ଆଣିବା
Surjanarayan bhai,
Era gudaye
Mr. Surjanarayan Patna
mane-
has filed this application. I will obtain the.
No, you see 200 କେତେ ନମ୍ବର application ହେଇଛି 181 ଟା original application dispose of ହେଇଥିଲା ସେ order ରେ।
After the first order, if you file any writ petition, we will impose cost.
ବର୍ତ୍ତମାନ ଦିଟା order ହେଇଗଲାଣି ତେଣୁ ଯଦି ଅଛି ଆଉ କିଛି ତା ନମ୍ବର ଦିଅନ୍ତୁ dispose of କରିଦବା ସେଗୁଡା ସବୁ ଦବ। ହଁ
Thereafter, we will impose cost. So there is no limit. You see, hundreds of ways are decided. Why are you choosing one after another? That
In fast
goes
net-
to show something.
In fast batch, number of cases dispose of. Only again after 8 years.
ପ୍ରଥମ ଏ order କେବେ ପାସ୍ ହେଇଥିଲା tribunal ରେ?
Tribunal 2017.
2017 ଶହେ କେତେଟା writ petition 181 ଟା original application dispose of ହେଲା common order pass ହେଲା ସବୁଥିରେ same
Yes.
ଆପଣ ପ୍ରଥମ ରିଟ୍ ଟା ଫାଇଲ କଲେ 2018 ରେ in respect of ଗୋଟେ ସେଇଟା dispose of ହେଇଗଲା 13/2/2020 ରେ ଆପଣ ଜାଣିଲେ ଯେ ଏଇ ଟାଇପ ର ସବୁ ଗୁଡାକ ଅର୍ଡର ହବ ପୁଣି ଏଇ ଯୋଉ ରିଟ୍ ଟା ଫାଇଲ କଲେ 2025 ରେ 5 ବର୍ଷ ପରେ ପୁଣି କଣ ପାଇଁ
Why?
file କଲେ?
Why selectively you are filing?
My lord,
That goes to
ଯଦି ଫାଇଲ କରିଥାନ୍ତେ 180 ଟା ଯାକ
Yes,
ଫାଇଲ
yes, my
କରିଥାନ୍ତେ
lord.
ଆପଣ ତାମାନେ ପିକ୍ ଆଣ୍ଡ ଚୁଜ୍ କରୁଛନ୍ତି ଅନ୍ୟମାନଙ୍କୁ ଯୋଉମାନେ ଆପଣଙ୍କୁ କଣ will not express
you know the reasons.
I don't mind know the reason.
I do not know
But
about
No, we will impose cost saying that who is the officer has taken
person
decision to
those who are
challenge it.
taking decision to file this type of writ application.
ନାଇଁ are you not supposed to impart 181 ଟା ମ୍ୟାଟର ରେ ଆପଣ ପିକ୍ ଆଣ୍ଡ ଚୁଜ୍ ଗୋଟେ ମ୍ୟାଟର କଲେ 2018 ରେ ଗଲା ସିଏ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲା 2020 ରେ ପୁଣି 2025 ରେ ଆଉ ଗୋଟେ ତା ଦେହରୁ ଆଣିଲେ ବର୍ତ୍ତମାନ ଆପଣଙ୍କ ପାଖରେ ଡାଟା ନାହିଁ ମଧ୍ୟ ଆଉ କେତେଟା ମ୍ୟାଟର ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିଦେବେ ultimately this order will be passed.
Yes, ma'am.
So
That's why I collect.
You are not wasting judicial time.
My lord, definitely.
See, this is not expected from a Union of India. Either you have a right to challenge, no problem. You challenge it, all the matters. But you can't pick up one matter, challenge it.
cost deposit କରିଦେଲେ ଆଉ
Post kariyo. We'll have
since
My lord.
earlier matter in respect of say you कौन था ना दामू माझी in WPC number 17189 of 2018 was disposed of on 13/2/2020 and knowing fully well that similar order will be passed in case challenge is made to any the common order passed in any of the original application which was disposed of by a common order. This writ petition was filed in 2025.
After 8 years.
After 8 years. The Land Council for the state has no instruction as to whether any challenge has been made to the common order passed in respect of the 180 of the rest of the original applications which was disposed of by the common order. 181 likhi deva total disposed of. Therefore, we do not appreciate the pick and choose method that has been adopted by the state to challenge the common order passed in 181 original application selectively file the retraction. Accordingly, we impose a cost of rupees 10,000 to bath.
Item 11.
Yes.
Item 11.
Yes, Mr. State Council, is your matter, State of Orissa. Item 11. एका मैटर अरे अच्छी कहिए नहीं
Same.
हाँ 11 टा सेम मैटर सेम ऑर्डर पे ताদের आउ 10,000 पड़ते है ना
ये नंबरটা कर
हाँ ठीक है नहीं हमें जान 20,000 तो हला तो बाहर रहो कौन
Item 12.
My lord, this case, my lord, petitioner is challenging the notice under section 13(8), my lord, 7 and 8, my lord. Here, my lord, the bank issue the e-auction notice, my lord. Can glance annexer 3, page 18, my lord. What is the difficulty the petitioner, my lord? Annexer 3, my lord, page 18, my lord. Here, my lord, the petition earlier obtained loan, my lord, and that installment is 144.
You are essentially challenging the possession note.
My lord.
Possession notice.
This is the restructure, my lord. First, my installment 144, my lord. Then after the COVID-19, my lord, they have reduced my installment.
But writings are somewhere else.
They are very certain. Not
My brother is appearing.
Alternative remedy available. Dispose upon now. Actually, going to appearing for the
Opposite party
bank. Yes.
I mean, pardon, my lord. No, my brother take instruction regarding if I be update have only 3
Your
lakh.
brother can do so much of things. What can he speak to him?
3,50,000 ମୋର ଖାଲି ଡେଫିସିଏନ୍ସି ଟା ଅଛି ଯା ଖାଲି ସେଇଟା ମୁଁ ଦବାକୁ ଅପଡେଟ୍ କରିଦେବି ଖାଲି ୟୋର ଲର୍ଡସିପ ଡାଇରେକ୍ଟ
କିଛି ନାହିଁ ତାକୁ ଏଣ୍ଟରଟେନ୍ କଲେ ଆସିଆଡୁ ଗୋଟେ ଚାଲି ଆସୁଛି ମଝିରେ
Item 13.
May I please? Union of India has filed this application challenging the order of the tribunal at Annexure 1, miles. At Annexure 1, that is the order passed by the Central Election Tribunal, page 16 to 31. Relevant person, page 31. Your lordship kindly have a glance to paragraph number 12. In the last occasion also, your lordship observed that since there is a relying on Madras High Court decision and Delhi High Court decision, the tribunal has passed this order. But so far the Madras High Court decision is concerned, which was relied by the Delhi High Court, those employees were not regular, their service, there is no break, my lord. Their continuity for which their service has been regularized. But here, the petition has tendered resignation from the project under Annexure 7. Yes.
The last order, 810.
Last order, your lordship. Order dated 8/10/2025 months. Onwards, the petition has been filed by the petitioner challenging the order dated 31st January 2025, passed by the Honorable Central Tribunal Cuttack in OA number so and so under Annexure 1. It appears that the opposite party, Dr. Manoj Kumar, has filed the aforesaid OA to count this service on 4/1/1988 to 15/3/2007, rendered in the National ICMR NIMR under the integrated IDVC project as qualifying service for all purposes, pension and other pension benefits by quashing the order date 26/4/2019, wherein the petitioner rejected his representation. After issuance of notice, the petitioner filed their counter affidavit, and the non-tribunal, after considering the submission made by the counsel for both the parties, the pleadings in the case and taking into account the ratio laid down by the Honorable Supreme Court.
So and so, yes.
So and so.
May I audible, my lord? May I audible, my lord?
Yeah.
My lord, what I am praying, my lord, it is a fact that this fact was not reviewed by the central government before the Central Administrative Tribunal. So, if lordship may protect because they are proceeding with the contempt. If lordship may give liberty, you can file a review. Thereafter, you come here. It is better. Subject to the consideration by my lord.
If you want to withdraw this petition, you can withdraw it. That is with
No,
you.
Mane, withdraw is not a surprise our problem, my lord. What I am
You just
praying,
made a submission
because
that you want to file a review petition. It is
no,
up to you.
no, my lord,
Why
not
is
the
that?
issue. What happened? Basing on the Madras High Court judgment, this there in Delhi, this case is completely different from our case.
So
Anyhow,
that is the submission, but once you are filing, we have to see that how it is different. But so far as review is, that is
when they
your,
consider merits, that issue.
yes.
Then my lord, so kindly see the paragraph number 12. Paragraph 12, it is a sound principle commonly accepted that when a particular set of employees is given relief by the court, all other identical situated persons need to be treated alike by extending that benefits. Not doing so amount to discrimination as would be violative Article 14 of the Constitution of India, State of Uttar Pradesh, such and such. As discussed above, since in compliance of the order of Honorable High Court of Madras, Chennai, and Honorable High Court of Delhi, the similar situated persons engaged on temporary public ad hoc basis under the project have regularized from the date of their initial engagement, and the whole period has been reckoned for the purpose of pension and pensionary benefits. We see no justification to deny the said benefits to the applicant herein. Therefore, the rejection of the claim of the applicant deserves annulled. Accordingly, the impugned order such and such is hereby passed.
What is the difference on fact?
Difference, my lord, here what happened? They also kindly have a glance to annexure 2, page 32 to
The
34.
principle, the tribunal says the principle is once an ad hoc employee is regularized, his past service, the ad hoc period will also be counted for the purpose of
Sir, here he is not ad hoc service. He was under a project. Annexure 7.
This is also project. That's what they say.
But there, my lord, he is continuity. There is no break. Here he has tendered resignation in order to join the ICMR. Your lordship, annexure 7, page 42, kindly have a glance. That is the page 42.
In those cases, Madras and Delhi case also, there was project. In the project only
but they have not tendered resignation in a higher post. Here, my lord, he has tendered resignation from the project in order to join the next post, my lord. SRO at NIMR Delhi, my lord. Your lordship, annexure 7. There was a vacant post of SRO at NIMR Delhi. Annexure 7, page 42. Was made by the council. I have applied for the said post, which was duly forwarded by the director NIMR Delhi to the Director General ICMR Delhi. Since I have applied through proper channel and I have been selected for the post of Senior Research Officer at NIMR Delhi by Council number so and so dated 7 March 2000 by following the usual procedure. As such, I am resignation from the post of Senior Research Scientist IDVC project, and this may be treated as technical resignation. My resignation may kindly be accepted from the afternoon 15/3/2007. So there he has tendered resignation, and we have regularized from 2013.
How many persons, when this observation has come by the given by the Lennon Tribunal, that as per the decision of the Honorable Supreme Court in the case of State of Uttar Pradesh versus Arvind Kumar Srivastava, several orders have been passed only by the High Court of Delhi, but also by Madras, and associated persons have been. So, how many such persons have been who are on temporary or ad hoc basis under the project have been regularized from
paragraph number 4.1, my lord. Paragraph number 4.1 of the judgment. There they have reflected two writ application of the Madras High Court and Delhi High Court. There are 11 persons. These are the orders, my
total 11 persons. Let us say, no, we are accepting you. So, ये जो 11 लोगों को जो order गुड़ा को pass ही Madras High Court रे,
again,
you challenge it in the higher court.
Higher court. Yeah, CAT has passed the order. Subsequently, Madras High Court dismissed her.
So he was working in one project, resigned and started working in another project.
Not project, ICMR.
That is also an institution. And he says that from 2007, I have been working continuity. What is great deal about
2007, but from 2007, your lordship kindly see, he has a tender 2007 में regularized करें from the project period.
The project period, that's what the court says that Bombay, Delhi High Court says that project period will be counted. Merely yes.
And that observation has, that has reached finality. You are
But
not-
there is no break. The observation, there is
One
no
more
break
thing,
in
why don't you
service.
consider he's a scientist?
There is
Why
no
are you
break.
troubling scientists?
There is no
See,
break in service. That is the only interpretation. There is no break in service. They are regular.
started working somewhere.
Opposite party resigned from the post and being selected, and all other more than 40 persons, my lord, have never been selected. They are continuing on ad hoc basis and subsequently regularized and past services have been counted. In the instant case, the petitioner being selected in the said post, in the said office also. He resigned one day and the next day he joined in the said
Cadre is
post.
completely
as regular.
different. Putting is completely different. Service cadre is
And that
completely
point has
different.
already raised
He
by
has
the
worked.
After utilizing the services of the scientists for so many years. Oh,
A small technicality because he resigned on the same day and joined in the
selected.
same.
He is
You
a
can't
my lord,
deprive the
because
past
this
service.
working in a project is a completely different working, and
No, that's not.
accepting
Part 12
as a
says that in
regular
project
employee
only.
in the organization.
No,
is a different.
para 12 of the impugn order says in the project, those people in Madras and Delhi, they were also working in project.
Yes, it is there. There is no dispute that there is not working in project.
And he is
Yes,
in
project only
a
issue is
better
that
position.
if they are continuing in project continuously is regularized, then this the decision is applicable to us.
See,
And you are
but the
separate.
difference is in those cases, they have been regularized. Ad hoc post is regularized. Here, what had happened is he got selected.
He is selected, so he is
He is better off.
Yes, so he resigned from this cadre, that post and contractual appointment and join is a regular post. That's why the previous
And
working
the order
period
passed
cannot
by
be
the
considered according to the
the
footing of
Honorable
this.
Madras High Court as well as Delhi High Court has been confirmed by
where is the
the
original application?
Original application, my lord.
60 of 2000.
Oh, the annex question.
Annex
Again.
1.
Annexure 1.
No, next one.
Original application है.
Ah.
Wait.
46 to 141, annexure 10, my lord.
Annexure 10.
Fine.
Page 46,
46.
my lord. Annexure
46 नहीं पड़ा को. 46 कौन सा 20 में था?
Judgment उड़ा.
Judgment उड़ा. Original application पे. अच्छा था और है 124 9 का. एक मिनट.
annexure.
बस सब उड़ा को थी अपन को ये judgment. काय original application पे.
Original application is there. It is there.
पूरी फोन आदि अपन को पहले 45 बोली 46 46 रे देखना कौन अछि. 46 रे उड़ा कुछ खाली decisions उड़ा को.
All judgments.
All judgments. अच्छी की.
See, madam, super index is 46.
Index टा कौन.
Again,
अब वो guide ला
again,
original application.
then I have-
अपन बार अच्छी copy.
I have given also. This is there, my boxes. This is 46.
ଏଇଟା ନୁହେଁ ମ. ଆପଣ ଯୋଉ original application ଟା
Again, ଅଛି 46 page ରେ ଅଛି.
ଏଇଟା ମୁଁ ଦେଇଥିଲି ତାଙ୍କୁ.
Application, that is the annexure 10, first page the index given by the applicant. 46 page 47 is the synopsis submitted before the tribunal. Then that is continuing.
ତାପରେ ତା decision
Where
उड़ा.
is the way?
Where is the way application?
OA application से तब पर
No. In submission thereafter, straight away the judgments. Moisture Verma judgment.
No, I don't know.
ଆପଣଙ୍କର ପିଟିସନ ଆପଣଙ୍କ ପାଖରେ କପି ନାହିଁ
Page 124.
Huh?
Page 124.
124
Ticket, he has filed this case before the Ranchi. Subsequently, this has been transferred to our. Yeah, my lord.
ଅଛି ନା ନାହିଁ
Again,
ଅରିଜିନାଲ ଆପ୍ଲିକେସନ ର ରିଲିଜ ସର୍ଟ ଫର ଆମକୁ ତୁମକୁ ହେଇକି ଯୋଉ
That is another order. OA copy is not there.
ଅର୍ଡର ଟେ କଣ ଲେଖା ହେଇଛି ନବୀନ ଟଣ୍ଡନ ଦେଖିଲେ
Yes. Similar order, I think.
ଏଗୁଡ଼ା ସବୁ ସିମିଲାର ଅର୍ଡର ଅଛି ତାପରେ ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଅଛି ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଅଛି ଏବଂ ତାପରେ ବୋଧେ ରିଜଏଣ୍ଡରଟା ଅଛି
OA copy ନାହିଁ
ওই କପିଟା ନାହିଁ
ଖାଲି ଓଏର ଇଣ୍ଡେକ୍ସଟାକୁ ଆନେକ୍ସ 146 ରେ ଆନେକ୍ସ କରୁଛନ୍ତି
ওইର ଇଣ୍ଡେକ୍ସଟା ଦେଇଛନ୍ତି ବଟ୍ ଏଇଟା ନାହିଁ
ନାଇଁ ସେଇଟା ହିଁ ଆଜ୍ଞା ସିଏ ତାଙ୍କର ଯୋଉ କ୍ରାଞ୍ଚିରେ ଫାଇଲ କରିଛନ୍ତି ଲର୍ଡସିପ କାଇଣ୍ଡଲି ସି ପେଜ 50 that is the original application ଛୋଟି original application page 50 lordship kindly see after the order sheet after the subject matter of the instant OA is to whether service rendered by the applicant from 4/1/1988 to 5/15/2007 would be counted for the purpose of
ওইর কপি
that is file again index re dekhontu wait only 6 pages thereafter he has annexed all the judgments to the original application before the Ranchi and prior your lordship submission then
ওইটা হচ্ছে 1 to 6 নয় এটা হচ্ছে synopsis of submission of Abhay Kumar Behera senior advocate
page 46
synopsis of submission of Abhay Kumar Behera
ওই হবো
that is the original application 692 before the Ranchi.
Mr. Behra, the senior counsel, has prepared a written note of submission along with the judgment that he has filed.
And the certified copy supplied by the KRT Lordship kindly see page 1 to 6, 7 to 4 judgments.
That is not the original application.
And certified copy recently I have received my lord.
Can you ওইর जो original application जो फाइल हबो जोठी भी फाइल हो ওটা প্রপার
yes that is in our format
ଆଉ ତାହେଲେ
ମୁଁ ତ certified copy I have applied the certified copy recently the CAT has given
that this is synopsis why can't you read them
my lord I have
very way we are asking
neither he is producing nor you are producing
One second, we check
we
it
want
out.
to see the prayer of in the way
you have filed the counter affidavit is here the rejoinder is here but the original application is not there the synopsis which has been filed along with the citation that is there but you want the original application
all of certified copy
ଆମେ ଆପ୍ଲାଏ କଲୁ ସେଇଟା ହିଁ ଦେଇଛନ୍ତି
but that's wrong
ଖୋଜି ରେକର୍ଡ ଖୋଜିକି ଦେଖାନ୍ତୁ ତାଙ୍କୁ
ଆଜ୍ଞା
ଏଇଟା କଣ ଦେଲେ ସେ ଆରଟା ଯୋଉଟା ଦରକାର original application details ଲେଖିଥିବେ ନା ସେ ତାଙ୍କ କେସ୍ ବି ଲେଖା ହେଇଥିବ where is your client
नहीं
do you have the copy of OA with you
date of this that I can produce
is the client your client
no
obtain that copy the land council for the Union of India also the land council appearing for the opposite party admits that the matter may be taken up some other day to file the original application which was filed before the code file is the
Ranchi bench subsequently transferred to Kata
before the
Central
Administrative Tribunal Ranchi bench which was transferred to the Central Administrative Tribunal Kata.
It was filed with the Central Judicial Patna Circuit Bench at Ranchi.
Patna Circuit Bench at Ranchi transferred to Swan. So transfer by the order of the
chairman Central.
Keber October. By 22nd of October 2025. Yes.
Chairman contempt is containing personal affairs of the health secretary.
appearing, one officer is appearing, director is appearing.
We have already passed the order on 8/10/2025.
And today they have fixed, my personal lordship direct, today they have fixed.
Pursuant to that direction, my lord, they did not appear. The Director General was directed to appear before the CAT, but he did not
Director
appear
General
on
was
that.
absent, Deputy Director General was
He
appeared. I
asked for
advised
time
him to
and
appear,
to raise
already
the
has
fixed one.
appeared.
Since last
Already the
6
Deputy Director General already has appeared.
2009 not getting pension mine because of this.
Who took that time?
It is stated that the content petition is posted today.
Today, my.
Today. The content petition, no adverse order for them. No adverse order shall be passed against the contemner till next date, 22nd of October 2025.
My lord, I have some personal difficulty. Can it be 23rd or 24th?
Mr. Bhokka is here, he will continue.
The 24th को जब
Yes,
24
Where are you coming from?
Yes. Original application आपण पाहिजे केमती
Behra senior advocate was conducting from the very beginning.
Yes, right.
So record is which.
May I pray because we are obtaining the original application. Well, more time, 27th or 28th is better.
I will produce. I will produce the original.
Nothing.
Yes, next 14.
Item 14.
No, please, my lord. The petitioner has challenged the order of the line Central Administrative Tribunal. Pay to 101, my lord. The operative portion of the order is 110, my lord.
Annexure 3.
My lord, 110. Operative portion of the order.
Yes.
It is unheard in service jurisdiction that one can be allowed to avail the fixation of pay on promotion twice for the same post. The last pay which the applicant was drawing.
Where are you reading? Page
101. 110, sorry.
But in the prayer you have written, there is a mistake, small mistake. You have written annexure 3 in the prayer block. Let's see. That should have been annexure 4. Let's see the prayer. You have said that so
order dated 21/2025 is annexure 4, not annexure 3.
in the prayer you
Annexure
have
4,
written-
man, actually, the improved order is 101.
What is annexure 4?
That is annexure 4, but
That is
your prayer.
my prayer, my lord.
Prayer
I
will
am
be
coming to
petition.
prayer, my lord. My prayer is 30, phase number 30, my lord.
1-3.
30.
Prayer Vasile.
My lord, it is therefore humbly prayed that in the circumstances stated above, your lordship would graciously be pleased to initiate rule in the nature of a writ of cited and or any other writ or writs calling upon the opposite parties to show cause as to why the order dated 21st March to 25 by annexure 3.
ସିଏ ତ କହୁଛ ବର୍ତ୍ତମାନ ପଳେଇ ଆସନ୍ତୁ।
It is unheard in service that one can be allowed to avail the fixation of pay on promotion twice for the same post. The last pay which the applicant was drawing, that is 1480 in the post of SM, joining in the reverted post of SM, was by virtue of allowing him the benefit of fixation of pay in the grade of SM, which he continued to enjoy the post of ASM till he got promoted to the post of SM. The rules which the applicant relied on do not speak that in the circumstances as in the instant case, the applicant is entitled to get the benefit of fixation even if he had already availed the same earlier. Law is well settled in a plethora of judicial pronouncements that the authority is competent enough to rectify the mistake at any point of time. The applicant also did not cite any authority to establish its cause as to return the fixation of pay erroneously fixed.
Once an employee and pay upon his promotion to a particular post by application of rule, which pay he or she enjoyed in the reverted post till his further promotion to the post said post, he or she cannot seek fix or pay on the said promotional post. Such benefit is not contemplated or envisaged either in the instructions, circulars of the value board or the rules. Therefore, we do not see any infirmity the decision-making process of the matter requiring judicial interference. In the result, both way 5/2019 and 21 cents merit are licenses which are dismissed accordingly. Another it is a common order, my lord.
What was your prayer before the London Central Administrative Tribunal?
My lord, page 30, my lord.
30,
An order declaring that reduction of pay, basic pay of the applicant for this month of December 2019 and January 2020 from 7,400 to 70,000 is illegal. An order declaring that the basic of the applicant at the time of retirement of the applicant was 74,300 in an order to issue directly the respondent to recalculate the pension, discharge and all other settlement dues of the applicant, treating rupees 74,300 as the last basic pay emoluments of the applicant at the time of retirement and payment of arrears with interest at the rate of 12% from the date of retirement. An order to issue declaring that recovery reduction from discharge of the applicant is illegal and refund of the deduction amount with interest 12%.
Why the reduction has been made? What is their counter affidavit stand?
Reduction is my lord.
Erroneously for 2 months, then they've corrected it.
My lord, the mistake was happened in the year 2794, my lord. My lord, the applicant was first appointed as a ASM in Adra division, my lord. Thereafter, he was promoted to the post of ASM. Thereafter, he
Come to page 108, para 6. Para 6. As it emerges. Read it, sir.
It emerges from after being recruited through a computer examination, joined the post of ASM, the pay of which was revised to rupees 12,240 with effect 1186 and was promoted to the post of SM in the pay scale of rupees 1,400 to 2,300 in November 80, and his pay in the grade of SM was fixed as per rules. He served inter-divisional own request transfer to Kharagpur division to a lower scale 12,240 on bottom-most seniority and on acceptance of request joined at Kharagpur division in January 91. It also reveals from the record that at the time of his joining at Kharagpur division, his basic pay was 1,480, and after his joining, when his pay was fixed at the scale to 200-240, he objected such fixation in lower scale and approached this tribunal along with others. UN number 7/1294, which was disposed upon 8496 with the direction to the railway authority to allow the applicant to draw pay at rupees 1,480 in Kharagpur division in pay scale 1200 to 2040 till the maximum of the new scale, and in compliance with the order, the applicant was allowed to enjoy the benefit of the pay fixation till he was promoted in news division to the post of SM 7797 in pay scale of 5,000 to 8,000, which was corresponding to scale 1,400 2,300. His date of increment was 1/12/97, and therefore his pay in his previous post ASM was at rupees 5,125. On his promotion, he opted fixation with effect to the date of his annual increment to 1/12/97, and therefore his post of SM was placed at the stage of pay 5,150 on 7/7/97. Thus, the pay in terms of Rule 1313 FR21 Chapter 1/12 ought to have been fixed at rupees 5,300. 5,150 plus 1 annual increment 5,150, but his pay was fixed at rupees 5,450 along with one additional increment under Rule 1313 FR21 1, which was subsequently found to be erroneous by the Accounts Department while reviewing the service receipts for the finalization pension paper, and the same was duly rectified. The said action has been challenged by the applicant in this instance.
So that was done when?
At the verge of the retirement, 2 months before, my lord.
That's the mistake.
That mistake was
That
detected.
mistake is rectified.
Yes, my lord, 7794. Actually,
So, they may not recover the amount from you, what has been paid extra to you, but if
4 lakhs, man, about 4 lakhs they have recovered because of that fixation 7797.
no,
My lord, the
recovery has already been made.
yes, my lord. They hold the entire discharge about 10 months.
Have you challenged the recovery part?
Recovery part.
That is their increment.
Recovery can't be done, but that is your
That is my favor, sir.
that is not your mistake. Erroneously, they calculated instead of 5,300, it was 5,450. And erroneously it has been paid to you. There is no question of recovery.
As per the provisions of the rules, by railway rules, that cannot be done, my lord.
What cannot be done?
That at the verge of retirement, that cannot be done.
Cannot means what? Recovery can't be done.
No, fixation, that, my lord, at phase number 47, my lord.
47.
As per the tribunal's view, there is no provision. But there is a provision in the railway rules.
Just a minute.
78, 78. Preparation of pension papers. Every head of office shall undertake the work by
1 minute. 47. 47 level.
Yes.
Every head of office shall undertake the work of preparation of pension papers in form of 7 2 years before the date on which the railway servant.
1 minute. Yes. Every head of department of please proceed.
Servant is due to return on super the date on which he proceeds on leave preparatory or journal. Second, 17, stage for the completion of pension papers. The head of office shall divide the period of preparation work 2 years, rapid in 17 in the following 3
You are reading 77.
Yes, my lord, 79.
29.
48 page, 79, my lord.
Yes. Head of the office.
There are 3 stages, my lord.
Yeah.
First stage, verification of service. The head of office shall go through the service book of the railway. The certificate of verification for the entire service are recorded therein. In respect to unverified portion of service, he shall arrange to verify the portion or portions of the such services, as the case may be, with reference to pay bills, acquittance rules, or other relevant records, and record necessary certificates in this service book. If the service for any period is not capable of being verified in the manner specified in subclause 1 and subclause 2, at that the period of service having been rendered by the railway servant in the order of other office or department, a reference shall be made to the head of office in which the railway servant is sworn to have.
Why are you reading entire? You said that it cannot be done at the fag end.
Next page, my lord, 49. Making good omissions in the service book, my lord.
Making good omission in the service book. Yes.
The head of office, while scrutinizing certificates of verification service, shall also identify if there are any other omissions, imperfections, or deficiencies which have a direct bearing on the determination of the emoluments and the service qualifying the pension. Every effort shall be made to complete the verification of service as in clause 1 and to make good omissions, imperfections, or deficiencies referred to in sub-clause 1 of this clause, and any omissions, imperfections, or deficiencies in personal service shown as very unfavored in the service which it has not been possible to verify in accordance with orders laid down in clause A shall be ignored, and service qualifying for pension shall
if
be.
If it is not verifiable,
yes.
If it is verifiable, it can't be ignored.
Well,
it says that if it is not verifiable, then ignore it. If they can verify it, they can correct it.
Well, I'm coming to the third statement.
Yes.
Roman 3.
Yes. For the
purpose of calculation of average emoluments, the head of office shall verify from the service book the correctness of the emoluments drawn or to be drawn during the last 10 months of the service, and in order to ensure that the emoluments during the last 10 months of service have been correctly shown in the service book, the head of office may verify the correctness of the emoluments for the period of 24 months only preceding the date of retirement of a railway servant and not for any period prior to that.
This is relevant.
Yes.
When was the date of retirement? When was the date of retirement? You retired?
Retired on 30 January 2020, my lord.
January?
20. They informed me in the month of December, my lord.
December
I came to know 19, December 19. I came to know when I got the pay slip of December, November 19. Then I came to know that they are going to reduce my pay.
All this rule is applicable once you retire.
Yes.
What is the procedure of calculation? Where you retire in January.
Yes.
But all this calculation business and everything has been done in 2019. For your retirement.
Well, they cannot put 24. They cannot.
Give the deadlines.
Well, it says the only 24. Beyond 24, they can rectify. Head of office may verify the correctness of emails for a period of 24 months only preceding date of retirement.
That we understand, but please give the dates. Which are the dates?
Retirement केबेटू ସେମାନେ verify କଲେ ଆପଣଙ୍କର ରିଟାୟାରମେଣ୍ଟ ହଉଛି 2020 ଜାନୁଆରୀ ସେମାନେ 24 ମାସ ପୂର୍ବର ହିଁ ଭେରିଫାଏ କରିବା କଥା ଆପଣ ଯୋଉ କହୁଛନ୍ତି ତା ପୂର୍ବର ଭେରିଫାଏ କରିକିନି କରେକ୍ସନ କରିକିନି ମଡିଫାଏ କଲେ ବୋଲି ଏ ଯୋଉ
ତା ପୂର୍ବରୁ ଯୋଉଟା କରେକ୍ସନ ମିଷ୍ଟେକ୍ ହେଇଛି ସେଟା କରେକ୍ସନ ହେବ
କେବେଠୁ କଲେ ବିପନ୍ନ ନା କଣ କେବେଠୁ ସେମାନେ କରିଛନ୍ତି
7797
ସେଇଆ କହୁନାହାନ୍ତି
rule
77/1997
yes madam.
So beyond the period of that 24 months तो ସେଇଟା ତ କହିଦେବ ଏତେ ଆଉ ବାକି ରିକଭରି ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ଆପଣ
yes sir
କୋଉଠି ରିକଭରି ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି What is your prayer?
In order to issue direct decline the recovery deduction for discharge of the applicant is illegal and a refund of the deducted amount.
1 minute, 1 minute, 10. Meanwhile, this meanwhile the applicant was promoted to the post of so it's submitted by the letter count of the applicant that although the applicant due the basic sale of 72 so till March 2019, the same was reduced to 70,000 from the March of April 2019 without any intimation. Also, so 20 to retire 2019 this has happened. So I will expect that one. Without intimation applicant, I will give you the absolutely
assessment जो करते देखुଛନ୍ତି ଯେ ଏଇଟା ଏ ଯୋଉ କହୁଛନ୍ତି ନା 97 ରୁ ଏ ପ୍ଲସ୍ ପଢିଲେ ପରା
ଏଇଟା ଫିକ୍ସେସନ ଆପେ
ଗଣ୍ଡଗୋଳ ହେଇଛି ଯୋଉଟା 97 ରେ ଅଧିକା ପାଇଯାଇନାହାନ୍ତି ସେ ଯୋଉ 150 ଟଙ୍କା ନା କଣ
1/12/1997
ସେଇଠୁ ସେ କାଲକୁଲେଟ କରିକିନା ଆସିଛନ୍ତି ଆସିକିନା ଅଲ୍ଟିମେଟଲି ସେଟା ସେ କହୁଛନ୍ତି ଯେ
whether the period will start from 97 or 2019 because calculation is done, reduction has been done in 2019, not in 97.
But you are coaching the alpha areas. You order the place good for us. The number is
8 years, 8 years, 108.
108.
Yes.
And I think you should have the points that we do the code.
नहीं 108 लाख तो कोई ना एक calculation था 96 तो
हाँ सीधा कौन ये जो 24 मास एक पेरियोड जो था कौन
हाँ that is ये
कोई ले अच्छी ना जरा देख ले
where is that provision you did 24-month preceding
that is railway services
yes 46 page
but let's see the page 80 R by 1 the railway board circular basing on which the initial they file a way since long thereafter he has pursued the promotion thereafter railway board circular is coming on position 28/1/2020
No,
That
no,
is-
what he's trying, Mr. Padi, what he's trying to say is the mistake has come, you have committed the mistake error in 1997 and that percolated and you calculated in 2019 only. So what he says that if the regulation is taken into consideration, preceding 24 months only you can go into. But it happened in 1997. That's why he says that you can't venture into that area.
That was clarified in our counter affidavit filed by the railway, page 71. Let's see page M.
21.
Yes.
Yes.
It starts from page 70. This applicant, as well as the fact that excess payment made to him, he knew that he had come on revision to lower scale of pay, and he was again promoted to his earlier scale of pay, on which he already got the benefit of pay protection in the lower post of ASM to KGP division, Kharagpur division, and he was not entitled to receive double promotional benefits as per the existing rules for the same scale promotion. But he deliberately remained silent to grab the public money by way of illegal means. Then, after receiving the clearance from all sections officers and DRJ amount was released after adjustment of the certified overpayment amount of 3,99,242, which is a public money from the DRJ due to as per the undertaking that had.
But when all these things have happened?
Yes,
97.
97.
Then that's what
It
he
is prior
says.
it is prior to 97.
That's then worst.
Then that's why. That's why.
This writ petition has been filed by petitioner Chandra Mohan Mahapatra, challenging the order dated 21/3/2025 passed by the Central Administrative Tribunal Cuttack Bench Cuttack in way number so and so. In dismissing both the original applications, I would have followed.
My lord, that is already that is also challenged.
No.
That is number 280.
But this ଆପଣ ଏଇଟା ବର୍ତ୍ତମାନ ହଉଛି କିଏ ଫାଇଲ କରିଛନ୍ତି?
ଚନ୍ଦ୍ରମୋହନ 21
ଚନ୍ଦ୍ରମୋହନ ଟା ହଉଛି ଆଚ୍ଛା 21 ଟା କଣ? way number 260 ସେଟା second page ଅଛି page 102 ରେ order dated so and so fasting way number 260 oblique 00021 of 2021. It appears that the petitioner filed the aforesaid way with the following prayers. Relief short for prayer. After issuance of notice, the counter affidavit was filed by the Union of India, and the petitioner also filed the rejoinder affidavit. The London Central Administrative Tribunal, after going through the pleadings and hearing and counsel for the parties, has been pleased to hold as follows. So you paragraph 6 जो किसी place कले, it is unheard in the service jurisprudence. That is page number internal page होची 10 और running page होची 110. Say to quote for to paragraph 6 end portion. Learning counsel for the petitioner refer to the report railway service pension manuals, chapter 7, which deals with determination and authorization of amounts of pension and gratuity. And in clause and in rule 79, it indicates about the 3 stages regarding completion of pension papers. So far as the second stage is concerned, as mentioned in Rule 79, it reads as follows. Quote, there are Roman 3 entirely quote code. The Learning Council submits that the provision makes it very clear that the verification regarding the correctness of the emolument is to be done preceding period of 24 months to the date of retirement. But in the case in hand, though the petitioner retired from services on January 2020, the verification that has been made was way back on 7/7/1997. And it is stated that on that day, 7/7/97 paragraph. On 7/7/97, and it is stated that it is observed by the learning tribunal relying on the counter affidavit stand taken by the opposite party that the pay in terms of Rule 133 FR 22 it has page number 109 running page 109 internal page 9 of annexure 4 and that is pay in terms of Rule 1313 FR 22(1) bracket A out of bracket 2 ought to have been fixed at rupees 500 bracket rupees 5100 plus 1 annual increment of rupees 150, but it's fixed at 5450 by allowing one additional increment under 1313 FR 22 bracket 1 out of bracket A bracket 1, which was subsequently found to be erroneous by the accounts department. Therefore, the
reviewing the service,
which was subsequently found to be erroneous by the account department while reviewing the service sheets for finalizing the pension papers, and the same was duly rectified. Therefore, it is apparent that the mistake which is stated to have occurred on 7/7/1997, granting and giving extra payment, giving additional increment was the ground for making the reduction in the month of March 2019. 2019
November 10. Retired January 20.
No, it केबे हला जो
November 19.
November while
they reduced in November 19.
fixation of pension.
Maybe November 19.
2001.
November 2019.
2019.
2019. November 2019. Which is contrary to the provision of the said Rule 79 of Chapter 6 of Railway Service Pension Manual.
He superannuated on January 20.
And the petitioner superannuated in January 2020. issue notice on the question of admission.
Chapter 7.
Chapter 7, the point chapter. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Mr. Swanso interception. Aukana Lekavo, Mr. Pari. Aukana Lekavo, Kundu.
Along with Mr. Guchan.
Mr. Guchan. And Central Government Council.
Yes, yes, yes.
All the opposite party will accept.
For all, man, for all.
Accept notice for all the opposite party. Extra copies of the writ petition be served on the Swanso. Matter to be posted after 4 weeks date. They will counter affidavit pending filed in the mail. এটা মানে আটজনে কি 27 জন আচ্ছা কিন্তু item number 29 হলো complete. It has been registry point out করছিল. It has been pointed out by Swanso. So the same shall be read as Swanso. This is not approved. Inadvertently type as Sompus Kumar Das instead of Magnum Swanso. So it has been corrected instead of upload so the format is the opposite party not a political but you can set it for security set out drop. Yes. Next.
Item 15.
I pray man, kind of technical listing.
Mr. Maharana Lanan, Senior Panel Counsel, appearing for the petition 6 for an adjournment put of this matter. Date keep. Yes, next.
Item 16.
Yes, Mr. Panda.
Item 16, there are 3 matters arising from a common judgment passed by the London CAT on dated 36/2025. Two of the matters have been numbered. One is listed today, another is not listed. They may all be tagged together.
The number put a copy.
The first one is I will thank you.
Give the number, Mr. Panda. You are Mr. Panda.
Malad.
Central Government Council submits that two other matters which arises out of the improved judgment improved order dated 36/2025 passed in way number 782 of 2020 is submitted before this court which are the number 20 and all these matter be listed together of this matter on such and such we say you did away with it. Yes, I did fix on the yes, next.
My lord, I am a pardon. I have instruction to appearing this writ petition, my lord.
Who's read?
Item 16.
Asha.
Also direct my lord to solve a copy of
You give your okalat now. There are 2 other matters. In that case, you are not appealing.
also I have instruction that.
Instructions are it are legal. So on so files wakalat nama the opposite party. Pradip took a copy of the writ petition we served on the land council for this one. By tomorrow. The matter be listed indicating the name of the land council for the opposite party in the court. Yes, next.
Item 17.
May I please be noted?
Yes.
Petitioner before your lordships, the successful bidder in an auction conducted by the DRT members. When the auction was to be held, the opposite party number 1 in the present petition filed a section 17 application with DRT challenging the process of auction. The DRT passed an interim order saying that the auction process may continue, but no sales certificate would be given. Ultimately, it was held that the auction is invalid because notice was not given to all the persons concerned. Ignoring the definition of borrower, ignoring the provisions of section 13.2, 13.4, Rule 2 and Rule 4, where the borrower, my lord, is the person who has mortgaged the property.
So that essay was allowed.
The essay was allowed.
Then
I carried, my lord, as the successful borrower, I carried this matter in appeal before DR80, my lords.
Right.
Unfortunately, my lord, the DR80, my lord, comes to a strange finding that I do not have a locus to challenge anything prior, which was done prior to the date of auction. So they have segregated that pre-auction. I do not have a right. Since the bank has not filed an appeal, I do not have a locus to point out the inherent lack of jurisdiction of the DR to interfere in the matter, and, my lord, the provisions of law which was ignored by the DRT to hold, my lord, that since notices have not been given to the borrowers, to all persons, the 13.2 notice is invalid, so also 13.4 notice is invalid, and all subsequent actions are invalid. So may I just place that particular provision of the DR80 order, my lord. The DR80 order, my lord, begins at Annex 13, page 110 minutes.
So, just a minute, you want to see the essay was filed by one Rajendra?
My lord, he is the borrower come mortgager.
Okay. So, you must have arrayed him as a party.
My lord, I have arrayed him as the opposite party number 1.
Okay. So, the order, if we read the order of the DRT, that is Annexure 11, and the relevant paragraph is the operative part of the order is at page number 84.
Page number 84. Okay. Where the essay was
come
allowed.
to paragraph number 7, the last that page 87.
84.
84 of paragraph 7.
Again.
In view of the
In view of the aforesaid facts and circumstances of the case, and the issues already answered in the preceding paragraph, and the decisions relied on by the applicant, the instant essay bearing essay number so and so is allowed in favor of the applicant, declaring the possession notice dated 4/3/2021 and e-auction sale notice dated 17/3/2021, fixing the date of sale 19/4/2021, are hereby set aside. The decisions on by the respondent number 1 to 3 and respondents 4 and 6, who are present petitioners before your lordships, are beyond the facts and circumstances of the case. Accordingly, issue number 6 is answered.
You are the respondent number
I am
4?
the respondent number 4 to 6,
Okay.
who were impleaded by the applicant. Initially, they had not arrayed me as party. Subsequently, they impleaded me, since we were the successful auction.
Okay, you challenge it.
I challenged it before the DR80.
What is the observation of
the observation, my lord, if your lordship put
page number
110, it begins, not Annex 13.
relevant
Relevant portion, my lord, is page number 118, paragraph 16, my lords.
Yes, please press it.
As far as the merits of the appeal are concerned, since the cause of action of the appellants, that is the highest bidder, arose only when the auction was conducted. Prior to that, actions were taken by the secured creditor. Secured creditor issued notices required under the SURFACE Act, but the same were set aside by the learned DRT. It was also accepted by the secured creditor. Hence, the applicant, that is the highest bidder, could not challenge these findings, which were recorded prior to the bidding in e-auction by the auction purchasers. Any action undertaken by the secured creditor before the e-auction is to be looked into as far as validity and legality of the action are concerned, and as far as it relates to the secured creditor, that is bank. There is a reason for that, because bank is secured creditor. Default and repayment of installments were made by the borrower guarantor. Account is to be classified as NPA.
But why bank not supporting you now?
The bank was supporting to me the entire process till the
bank should have come.
Bank has not come.
Not supporting you.
You are the successful bidder. So why the bank is not supporting?
For reasons best known to them.
But better you persuade the bank to challenge this order.
Because I can't. Unfortunately, what has happened in this case, because of the interim order, the subsequent auctions, bank was ready again to.
But the reasoning of the DRT is correct.
No, the reason of the DR80, my lord, is that
correct.
I do not have a.
Yes, of course.
To challenge to that.
I can only challenge my humble contention, my lord, is that I, being a necessary party, and appeal, my lord, is, my lord, a statutory right. I have, my lord, in my humble submission, my lords, all the rights to challenge because of the 13 to validity
But
of
the cause of action, insofar as you are concerned, accrue after the auction sale is done.
No, what has happened in this case, my lord, is once I am impleaded as a party, with great respect, my lords, I am a necessary party and I was impleaded rightly, my lord, on the directions of the DRT. So once I am a necessary and a proper party, my lord, I am locus.
Because your right is affected. That's what.
My right is affected because I have already paid 4.5 crores.
You can't be under the mercy of the bank now
My lord,
because you have paid
my
the
lord,
money and
I
all.
paid for 4.5 crores with a reasonable expectation, my lord, that the auction will go through.
This writ petition has been filed by the petitioners, Prabodh Mahanti, Pragati Mahanti, and Pradipta Mahanti, challenging the order dated 25/8/2025, passed by the Debt Recovery Appellate Tribunal, Kolkata, in regular appeal number 142 of 2023. Also, the order dated 11/10/2023, passed by the Land and Debt Recovery Tribunal, Cuttack, in essay number 50 of 2020, with a further prayer for a direction to the opposite party number 4, the authorized officer, Union Bank of India, to grant sale certificate to the petitioners. The Mishra Coral and Senior Advocate, appearing for the petitioner, submits that Rajendra Tusawat, the opposite party number 1, filed essay number 50 of 2021 before the Land and Debt Recovery Tribunal, Cuttack, under section 7 of the Surface Act, to quash all the steps in furtherance of the notices purportedly issued under section 13(2) and 13(4) of the Surface Act, including the auction sale notice dated 17th March 2021 and publication dated 18/3/2021. The petitioners were arrayed as respondents number 456 in the said. The Land DRT has been pleased to allow the essay and declared that the possession notice dated 4/3/2021, e-auction sale notice 17/3/2021, are not sustainable in the eyes of law and set aside the same. The petitioners challenged the aforesaid order passed by the Land and DRT before the Land and DRAT. However, the Land and DRAT has been pleased to hold in paragraph number 16 of the impugned order dated 25/8/2025 that the petitioners are the highest bidders and the cause of action, so far as the petitioners are concerned, arose only when the auction was conducted. And prior to that, actions were taken by the secured creditor who issued the notices under the Surface Act, which has been set up by DRT, and it was accepted by the secured creditor, and the petitioners are the highest bidder could not challenge those findings which were recorded prior to the bidding in the e-auction by auction purchasers. Stop. Mr. Coral and Senior Advocate argued that it is best known to the bank why they have not challenged the order dated 2023 passed by the Learning Presiding Officer DRT in SN number 50 of 2021. Even though the petitioners were declared as the successful bidder and they have deposited a sum of rupees 4 crores.
4.5 crores.
4.5 crores.
Sorry, I'm sorry, 4.19. I'm stand corrected.
4
crores 19 lakhs 25,000.
4 crores and 19 lakhs.
19 lakhs 25,000.
25,000.
25% of the total.
Which is with the bank. And they are proposing to go for a fresh auction. That is your issue. Stop. The Land Council for the petitioner urged that the findings arrived at by the Land DRT, so also by the Land DRT, are not sustainable in the eyes of law. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Requisite no notice be issued to the opposite party number 6 and 7. So far as opposite party number 1 to 5 are concerned, requisites for issuance of notice to be filed. Can we file by 17th of October 2025. Matter be placed 4 weeks per day.
Speed post.
IAN number so and so is an application for the day of operation of the orders dated so and so passed by the DRT so and so.
But ideally, fresh option should carry out, and let us see what is the value.
No,
and you have to match it.
With great respect, both the DRT and DRAT hold that the valuation is correct because he had.
What is the reserve price now?
The reserve price, my lord, was 15 crores then, and he had 16, and I had quoted for 16.
This the fresh option.
They have not conducted. They were advertising.
Then he has to match.
No notice. But they are attempting because they are now trying to force me to take back that 4 point some odd crores so that they can work out the other remedies as per the Securitization Act. And I was enjoying a stay, my lord, during the pendency of the appeal. The lordship would finally see.
Okay.
And interestingly, when during the time of admission and granting of stay, they say, my lord, the appellate tribunal found that there are serious grounds to be considered. But unfortunately, on the ground, locals, they have dismissed my applications.
Stay the operation.
After hearing the
and no further third-party interest to be created. That will.
And using the grounds taken in this one. Since the petitioner is the successful bidder by the bank, declared by the bank, and he has deposited an amount of rupees also. There will be a stay of operation of the order dated so on, and no third-party interest.
Greatly appreciated. Great to know. May I take notice by speed post? By speed post, may I take notice by speed post because
that is to be filed, requisites to be filed by 17th of October.
Greatly appreciated. My lord, item number 23 I mentioned, can it be taken up tomorrow?
Tomorrow, day after.
23. This is very urgent, but
21, 25, trial 1 to 18. So, formal application.
Lordship is directing day after tomorrow. Lordship may kindly do a favor to put it top of the list.
mention କରିଦେବେ ସେଇଦିନ ନେଇଯିବେ। କଣ
CRLMC formal orders ରେ ଆସିଛି conversion of quashing the proceeding from writ petition under the special CRLMC. Item number 25.
This case for not, sir.
Common mention.
Because we took place 2 nights for that each application was filed my lords. This is similar prayer that I am permitted to file the revision petition. My lords, I am appealing that case. The case is posted after for hearing. Sensing something
No, I miss.
that I may permitted to convert.
This is that was against discharge order, which is a final order. Here it is passing the proceeding, which is not against a final order. So therefore, here CRLMC will lie, not revision.
No,
that is
but,
very clear.
Why are you not filing if you intend to say that please convert it to so and so? Then you have to file an interim application, or you withdraw it and file the.
But I filed the interim application today.
What is the interim application?
Interim application is on record by notes.
184.
And that IA is pursuant to your last lordship's order also. This IA number 18184 of 2025, which is placed before your lordship. Earlier, there was an order. My learned friend has not gone through that order.
I've got the copy of the order. So
There is an order already by the division bench of this court that your lordship is directed to file a CRLRV. But here, my lords, CRLRV is not maintainable in view of passing a procedure.
Your lordship pass that orders directing the petitioner. And in fact, that application, he has filed earlier application for conversion. Allowed. He was allowed to
that
file
is another case.
Let me place it.
We had filed,
You filed the revision. Revision
This is
petition
my
filed.
case. I am the
Now it will
petitioner.
say on the
But I never suppress any facts. Let me.
You just permit to play. The case is pending.
Another case.
Case is day after
That
tomorrow.
is another case. This is another case.
No.
Here,
The
this is
same matter. Same matter in order.
This is WPC 23609. That is a different CRL.
After lunch.
Ultimately, we are not deciding the matter on merit.
My lord.
He has just filed an application that he wants to convert it to CRLMC.
Same matter, my lord. A revision is pending. Case.
Please point out that, so one of the application will be disposed of if against the self-same order he is filing the CRLMC as well as revision. Then one is to be disposed of. The other is to be considered on merit.
Should be given handles to go from one
Not
place
that,
to
let's
another.
take it order of discharge.
The same matter.
This order is much earlier writ petition which I
And
did
then
file.
something I
That is
missed.
a
No, the earlier writ petition, what have you challenged in the?
This writ petition I have filed for passing of
No, talking
proceeding.
about this writ petition which is saying.
That
You
is
asked for a
against- That
conversion
is against an order of discharge.
discharge. And
Discharge. Here,
passing.
passing the proceeding.
passing.
That is different cause of action.
Not all the same matter.
Correct? Yeah.
Same matters, my lord. Same matter. That bench was not inclined, my lord. That's why, my lord, sensing something.
IA number 18114 of 2025. There is an application which has been filed by the petitioner, Damodar Pradhani, for conversion of the nomenclature from WPC to CRLMC. The Land Council for the petitioner argued, Mr. Rotha argued that since in the writ petition, prayer has been made to quash the entire proceeding in TR number 15/35 of 2015/2014 pending in the court of London Special Court Vigilance Bhubaneswar. A CRLMC application is maintainable, and therefore the conversion may be allowed. Mr. Land Council appearing for the Vigilance Department opposed on the ground that the petitioner has filed a writ petition earlier challenging the discharge order, and
Letter on.
that was
Letter of this.
a conversion application was also filed in the writ petition.
And accordingly, it has been converted to a criminal revision.
Yes,
That is,
120 of 2020. And the page is assessing the matters.
To find it, share link procedure that will be waived. Necessary registry will be troubled.
It is to be CRL number, it is to be number and placed before the assigned bench.
See, this petition is not maintainable. Why should we pass an order? Bench only. They allow you to file.
Day after tomorrow for.
And it is stated that the revision is posted to so and so. In view of such submission, we permit the petitioner to withdraw the petition and to file a CRLMC application if so advised. Accordingly, the writ petition is disclosed.
Well, promoter conversion, you also be direct for promoter conversion.
My lords.
You may pardon, my lord. Item 43, I have filed a IA for interim bail. I have already supplied the copy. Let them take instruction. 43.
Your big pardon, my JCRL is not doing. JCRL,
Criminal offense. With this Mishra class issued 1310 minutes. My lord, sir, please to grant bail. But in another, I couldn't add the IA for the stale resist 5 minutes.
I have a pardon to make a mention of appeal bail matter, Lordship.
The item 31, instruction was there, the father of the petitioner died. It was there in day before yesterday.
31.
Yes. ସେଦିନ ପୋଲିସ କହିଥିଲେ ହଁ ମରିଛନ୍ତି କିନ୍ତୁ ଲେଖା ପକେଇ ନଥିଲେ।
ଆପଣଙ୍କର 31 ଟା ଡାକିକି ଡାକିକି ଆମର ଲାଷ୍ଟ ୱିକରେ ବୋଧେ ଡେଥ୍ ହେଇଥିଲା। 9th ରେ ଅଛି ସମୟ ଅଛି ଡାକିକି ୟେସ୍ ଆଇଏ ନମ୍ବର 177
ନାଇଁ 2597
ଏଇଟା
ଆଜ୍ଞା
Often instruction
OPD card and all of them.
Yes, my lord. I have
I
applied
number,
just now another course.
Item 43. 43, IN number 2597 of 2025 is an application for interim bail on the ground of element of the
Wife of
the petitioner who is stated to be suffering from various diseases, medical documents in respect supporting the governments has been annexed to the interim application. And counsel for the state has received the copy of the interim application, 6 some time, put up this matter. For this cycle, yes.
Oh, pleasure.
So please. So please, assume. They should also continue. Done.
Supplementary list, item number 1.
My lord, defect removed. Remove kari nahi.
Now appears from to at the time of all defects as pointed out, which transmitter will be removed within 2 weeks. केबे डिफेक्ट रिमूव कले
Kari nahi.
ओ करी नाहांती
ना.
करनाहांती केते समय दरकार डिफेक्ट कोन जानि छ ना नहीं
हाँ.
कोन
सेटा होची पारा 2 रे आपनकर कोर्ट ना आउ केस नंबर. पारा 4 रे.
डिले अछि 96 दिन मैं अपन गोटे इंटरिम एप्लिकेशन फाइल करछंती बाकी नेम ऑफ द ट्रायल कोर्ट डेट ऑफ जजमेंट केस नंबर नॉट मेंशन्ड you in being aggrieved paragraph रे para number 4 has been marked twice so and so तो এইটা করি হবো এইটা কোন এই সপ্তাহ ভিতরে কর দিও তো কমিং উইক Says Rebati Lota Panda, Land Council submits that she will remove the defect as pointed out by the stamp reporter during course of this week. In case such defects are removed, the matter will be listed on 24th of or 27th of October 2025 for 27 राशि. डिफेक्ट अब इस सप्ताह भीतर रिमूव करूँ तो 27/10 रे एडमिशन पे आसी ये
Item 2.
बेल अछि
His bail was both the appellants' bail was cancelled by this honorable court. I had order dated 10/4/2023. Thereafter, I was illegal. After the now they are pushing that. And after my engagement through legal aid, the previous council filed an I for recall. Therefore, my lord, I am
Why the bill was cancelled?
because non-appearance of the councils. On each date, the previous council has not appeared before this assembly.
order dated 10/4/2023. The procedure has been laid down that when the appeal comes up for hearing, notice has to be issued. If the council does not also appear, and accordingly notice was issued, but you did not
That was whether he will.
ছাড়ন্ত সে আইএ ফাইলে
We have appointed you.
That was whether he will.
ছাড়ন্ত সে আইএ ফাইলে
We have appointed you. You are the judge, that's all. Because earlier the previous council didn't appear, therefore the bail granted was cancelled, recalled. This was the conduct.
I pray one thing, day after tomorrow for final hearing.
Day after tomorrow, you get ready, we are questioning it 27. Mr. Vikas Chandra Floria, Land Council submits that he has received the copy of the paper book and time for preparation, and the matter will be taken up a week after for a hearing. Put up this matter on 27th October 2025 for hearing. Yes, next.
Item 3.
Item 3, please, my lords. On the last occasion, status report was called for, my lords, and the applicant is paid, my lords. Died. Look, in the following.
Sole appellant, Ramchandra.
Yes, yes, sir.
But judgment indicates regional trial face করছিল আলাদা তখন অ্যাক্টিভিটি লেইଥିଲା না ଗୋଟେ ତିଳୋତ୍ତମ ସାମଲ ବୋଲି ଜଣେ କିଏ ସେ ଟ୍ରାଏଲ ଫେସ୍ କରୁଥିଲା ବ୍ରାଣ୍ଡ ସାଙ୍ଗରେ କିଛି କଣ ଦେଖାଯାଉନି ଦେଖି ଇଏଟା ପେପର ବୁକଟା ହେଇଛି ପୁରା ପେପର ଜଜମେଣ୍ଟଟା ଦେଖା ହଁ ପେପର ବୁକଟା କାଢ ହଁ ତିଳୋତ୍ତମ ଟ୍ରାଏଲ ଫେସ୍ କରୁଥିଲା ତାର କଣ ହେଲା
कुछ तुम्हारा संभव विनम्र feeding her innocence to return from the prosecution on whose there were sealed impression. Mono Central of Atlantic is submitted on her there that she is mother of the two children, but it is best by her husband. No previous condition is proved against her, considering all these circumstances and more so when only two number of podcasts were recovered and seized from house. I think that I find that 1,000 to her for the offense.
ନାଇଁ ନାଇଁ ଏ ଯୋଉ ତିଳୋତ୍ତମର ଆକ୍ୟୁଟାଲ କାହିଁ କୋଉଠି ଲେଖିଛନ୍ତି କନଭିକ୍ସନ ତ ହେଇଛି ୟାକୁ ରାମଚନ୍ଦ୍ର ଦାସ
ସେଥିରେ 19 minutes he has been convicted under 379 only and punished with 1,000
379.
ଓହୋ appeal file କରିନଥିଲେ ସେ ଛାଡ ଏଇଟା ହଉଛି ତାମାନେ only for the land council for the state has produced the written instructions received from Superintendent Sub-Jail Nursing Court dated 29/4/2025. There's the appellant Ramachandra Das son of Nilamani Das, village Yamadi Court, Nigeria. Is uttered, expired on 2/12/2012. The report is taken on record. Since no application was in years related under section 390 post 1, so the appeal has assessed. Look, this is. Data conclusion.
Item 4.
For your lordships, lordship directed to take instruction regarding well-being of the
appellant plots. Sole appellant. Sole appellant. Found that the appellant so and so is staying in his house situated in so and so. ठीक है तो इटा हबो हियरिंग हबो पेपर बुक है तो हां पेपर बुक है बेसिक हां so you get prepared will take up on 27 yes sir like on the land council for the state has produced written instruction received from IAC Sadar Police Station Puri which shows that the appellant is alive and he is staying in village. The report is taken on record. The Last Land Council for the appellant submits that he has received the paper book and took some time for preparation of the hearing accordingly to this matter on 27th of October 2025. Yes.
Item 5.
କଣ ହେଲା report? ଅଛି ନା
two appellant ଗୋଟେ appellant ରେ ଆସିଛି କିନ୍ତୁ ସେ ଅଲଗା jail କୁ transfer ହେଇଛି. That has nothing common. So I take some more time to
no କାହାର ଆସିଛି ପଥୁକାରୁଆ ଅଛି ନା ନାହିଁ ମଝିଛି ନା and to transfer to your jail on so and so for further confinement and you are requested to submit the required information. এইটা তো ଆପଣଙ୍କ ଚିଠିଟା ନା ନା ଏଟା କାହା ଚିଠି କେଉଁ ଜେଲ ଲେଖିଛି ବରବିଲ ତ ବରବିଲରୁ ଆପଣ କିଛି ପାଇନାହାନ୍ତି
and the second Ramesh report ଆସିନି.
ଆଚ୍ଛା ରମେଶର କିଛି ଆସିନି ଆଚ୍ଛା ଏଇଟା ଲେଖନ୍ତୁ ତାହେଲେ JCRL number 58 of 2006, item number 5. Land Council for the state has produced the written instruction dated 6/5/2025 received from Superintendent District Jail Punjab, which is addressed to Superintendent Sub-Jail Barville, that the appellant was transferred to Barville Sub-Jail on 31/10/2009 and he was requested to give the required information on the Land Council for the state submits that information is yet to be required from the sub-jail Barville and the matter may be taken up on some other day. Put of this matter on 27th October 2025. We look at them, please. CRL number 450 of 2005. Tapre 450 लिखिए. Land Council for the state submits that instruction has been already sought for. Huh?
The instruction has not been received.
कहीं पर लिखा है report of the IIC regarding well-being of government would have not received लिखा है. उन पुआइला पर ऑर्डर है कि ଗୋଟେ କମନ ଅର୍ଡର ହେଇନି କି ସେଇ ଅନୁଯାୟୀ ଆପଣ ଇଏ କରିବେ ନା ଆପଣ ଆମେ କହିଦେଲୁ ଯେତିକ ଏଇ ପର୍ଯ୍ୟନ୍ତ ଅଛି ଆପଣ ସବୁଥିରେ ନେଇ ଆସିବେ ୱେଲବିଂ ରିପୋର୍ଟ ଆପଣ ସବୁତକ ଫାଇଲରେ ଇଣ୍ଡିଭିଜୁଆଲି ପାସ୍ କରିବେ ନା ଆପଣ 450 लेके जाना the council for the state note मगे देवे more time to obtain the well-being report of the appellant from the IAC to the IAC Joda police station. Put up this matter along with जो JCRL on 27/10/2025 है ना Mr. Pithal and senior advocate is present, huh? Here. Next.
Item 6.
The report Ochi alive. Who is the counsel?
I'm appearing in one case.
Who done it?
That is criminal appeal number 427.
427.
Aye.
ଆପଣ ଏ ଦିଟା କରିବେ ଆଉ କଣ ଆର ଦିଟା ତୁ ତ ଏକା ଜଜମେଣ୍ଟ କୁ ଆସିଥିବ ଆଉ କଣ ରେଡି ଅଛନ୍ତି ତ
ଆଜି ମୁଁ ଆରଟା ରେଡି ଥିଲି କାଲି ସେ ମିଷ୍ଟେକ୍ ହେଇଥିଲା ବୋଲି ମୁଁ ଆଜି ଏଇଟା ରେଡି ହେଇକି ଆସିଛି ଗୋଟେ ବ୍ଲାକ୍ ଲିଷ୍ଟ ଗୋଟେ କରିଦେବି
ନାଇଁ ଏଇ ତ ଏକା ଜଜମେଣ୍ଟ ମାନେ
ଆଇଟମ ନମ୍ବର 6 ଟାକୁ ଯଦି ଟେକଅପ୍ କରିବି କାଲିକୁ ବି ପରଦିନ କଲେ କହିବି ଆଇଟମ 5 ଟା ମୁଁ ରେଡି ଥିଲି ଯେ ଛୋଟ କେସଟା
ମରି ମାରି ଯାଇଛନ୍ତି ଅନନେସେସରି ଆମ କାହିଁକି ମରିଥିବ କଣ ହେଇଯିବ এইটা লিখে দিଅନ୍ତୁ আইটম নম্বর 6 CRLA number JCRLA number 104 of 2006.
I think I'm appearing for two appellants, appellant number 3 and 5. Because it's a transport brief.
नहीं ଆପଣ CRLA number 427 ने
हाँ 427 ରେ ଦି ଜଣଙ୍କ ପାଇଁ
ହଁ ହଉ ସମସ୍ତଙ୍କ ପାଇଁ କରିବେ ଆଉ ଲେଖନ୍ତୁ JCR 104 of 2006 non-appeals for the JCRLA work କେତେ ଜଣ ସେଥିରେ ଅଛନ୍ତି
5 ଜଣ ଅଛନ୍ତି
JCRLA
5 criminal appeal 427 ରେ 5 ଜଣ
ହଁ JCRLA ରେ ଅଛନ୍ତି 2 ଜଣ non-appeals since Mr. B.P. Hall and senior advocate is appearing in the connected appeal CRLA number 427 of 2006 for some of the appellants to request Mr. We engage the amicus curiae for the appellants. Accordingly, the name of Mr. P.P. Hall be reflected in the cause list. The names of other counsels shall not be reflected in the cause list. तापर सेम ऑर्डर कर दियंतु सीआरएल नंबर 410 of 2006 अछंदी धनंजय मुंडू नांदी नॉन अपीयर्स कर दियंतु मिस्टर गॉड इज एंगेज्ड एज द अमाइकस क्यूरी है ना बाकी तापर
he was present when it
Mr.
Mood was there
नांदी
I'll call
अच्छा तो
and he can brief you
yes
Mr. non appeals कर दियंतु engage for them to Mr. D.P. Donku. After CRLA number 427 of 2006, Mr. D.P. Don is present for apparent number. कहाँ पे अचंदी अपन 436 में?
It seems my lord Santosh Behra and 3
Santosh Behra
3 and 5
apparent number 3 and 5. The council were appearing were filed wakalatnama for apparent number 1, 2 and 4 are not appearing. Mr. Lord is engaged as the amicus curiae for apparent number 1, 2 and 5 also. Accordingly, the name of the other council except Mr. Lord shall not be reflected in the cause list henceforth. This CRL will be listed along with the CRL number 10 of 2006 and 410 of 2006. On 30th तारीख list for this.
2710
हाँ
2710 item number 5 has also
5 था that 8 of 29 कर दो 29 से 200 2006 sorry 2025 तो ना 2910 और without 5 yes looking for name of other and shall not be reflected in yes next
Item 7.
Mr. Jafrullah. Well-being कौन आसिला? अच्छी ना नहीं? Single appellant?
Yes, Your Lordship. Sole appellant.
After Mishra.
After me.
The Land Council for the state has produced the written instruction received from IIC, Mount Police Station dated 7/7/2025 to show that the appellant is alive. The written instruction is taken on record. Hello. So now Mr. Naik is to argue this matter.
Yes,
He has
sir.
been engaged. The name of Mr. S.K. Jafrullah. DPS Sri Rai? Yeah, the Jafrullah को junior assistant.
6/21 मेडलर ऑर्डरटा देखंतु ऑलरेडी विश्वजित नायक को ना ऑलरेडी रिकॉर्ड अछि तो नाटा कटा है जफरुल्लाह सं को ना कटा है
पूरा
6/1/2021 we appoint Mr. Biswajit Naik as my cause.
जगह दिला था. Appearing for this one same panel, the decision director to collect the copy of the paper. हाँ तो रोइला हो कौन?
आगे
हाँ आपन ना कौन?
शताब्दी सामंत Your Lordship.
तो ले दी जाओ ना कटी जो.
Your Lordship.
The names of Mr. S.K. Jafrullah, DPS Sri Rai shall not be reflected in the cause list. So ये पहुंची ची argument कौन दो? बड़े वाले नायक.
My lord, sir, keep it to next week's.
अच्छा, put up this matter on 22nd November, 10/2025 for hearing. Yes, next.
Item 8.
Mr. Mitra. कौन आसला? Report कौन? Vanchi ji. Marjay ji. Single appellant. Yeah. The Land Council for the state has produced written instruction received from Senior Superintendent Surface Sahoo Hon'Ble, which indicates that the appellant Suresh Guru alias Luthura expired on 28/2022. The report is taken on record. Since no nearly filed any application for continuance of the appeal under section 390 order of the appeal abates and disposed of.
Item 9.
Nisha Agrawal, Mr. Ramakant Mahapatra. Prisoner's petition received at Flat C, praying for engagement of Mr. Ramakant Mahapatra. Flat C again. Ramakant Mahapatra na dito na. It has a good file. Prisoner's petition of appellant received at Class C, praying for engagement of advocate Ramakant Mahapatra. लिखा ही कुछ
ना सरकारी वकील
हाँ
खाली सरकारी वकील
वो इठी लिखा ही ऊपर लिखा ही विषय बोलते ऊपर लिखा है इनर केस विचार पाई सरकारी वकील माने सरकारी वकील में से एक लीगल काउंसिल
लेटर बलांगीर जेल लेटर
हाँ
बलांगीर जेल लेटर लास्ट दी जज इन चार्ज पेपर रूम सुंदरगढ़ सेही कोई रास्ता जिसेल 49/15 संदन
2016
That is what is this for?
ହଁ ତାପରେ କଣ ଥିଲା?
ସବୁ ପୁରା take up କରିନି।
ରମାକାନ୍ତ ମହାପାତ୍ର କିଏ? ସେ ତା ନମ୍ବର ଫମ୍ବର ଦେଇନି, ତା ନାଁ ଆସୁଛି କେହି ନାହାନ୍ତି। 2016 କାର୍ଡ ବୁଝି ଦେଇଥିବ ଗୋଟେ ଲେଖିଦେଇ ପଳା। এটা ଲେଖନ୍ତୁ JCRL number 49 of 2015. Prisoner's petition has been received, which is at flag C, praying for engagement of Mr. Ramakant Mahapatra as his advocate. The name of Mr. Ramakant Mahapatra has also been reflected in the cause list. No one appears. When prisoners' petitions are sent from different jails, only the name of the learned advocate whom the convict want to engage is mentioned, and neither without any contact number, and even the address of the learned counsel is also not mentioned therein, and it becomes difficult on the part of this court to know whether the said counsel is a High Court practitioner and or not, and so henceforth this court feels it necessary that while forwarding such prisoner's petition for engagement of a counsel in which the name of a counsel is mentioned by the convict, to be engaged as an advocate, the address of the counsel, if known to the convict, so also the contact number be reflected in order to facilitate the registry to contact the learned counsel in case no one appears on the date fixed on the no one appears on the date of listing of the case. This order be sent by the registered judiciary to the DG presence, which shall be communicated to all the jails to do the needful. So, since in the present case, the information has been received from Special Subjail Bonaigaon in the prisoner's petition dated is 24/1/2016, and it's received from Special Subjail Bonaigaon. Less a fresh less instruction be obtained from the concerned jail authority regarding the contact number and address of Mr. Ramakant Mahapatra, whose name finds place in the prisoner's petition. A tweak of the order be handed over to the Land and Council for the state. Matter be listed on 27th of October 2025. Allah. And I would like to sometimes in the name of same name, there are a number of council who are practicing in the High Court. Therefore, it is difficult to ascertain which whom particularly we want to engage as the associate. Yes.
Mr. Pastor, sir, please.
Which matter?
31.
Just a minute. I will finish 10, then we'll. Yes, item number 10.
Item 10.
Under item 10, today I have received the paper book.
What is your name?
Karnil Sattar. Karnil Sattar. On behalf of Haripad Mahanti.
Haripad Mahanti. So, where is your senior?
He is held up in another court.
Huh?
He is held up in another court, hence I have mentioned.
So why you did not receive paper book earlier?
Yesterday.
When the paper books are made ready, it is notified. So you are supposed to receive the paper book, you mean your senior. So on the date when the matter is heard or hearing, you will say that I have received the paper book today and give me some time to prepare the case. And it's a jail criminal appeal. Your senior has been engaged by the Legal Services Authority. So we are granting you time. It will be listed on 27. Tell your senior to get ready for hearing. Mention is made on Mr. Vai Swanso on behalf of Mr. That the paper book has been received by his senior today, and some time will be granted for preparation for the hearing of the jail criminal appeal. This matter on 27th of October 2025. Yes, next. Now,
Item 31. The report has come. Yes. Other objects are attached.
This is item number 31. CRA number 669 of 2024. There would have filed IN number 2746 of 25.
2746 तक देह खराब थी बापांगरो 2770
नहीं सीधा IN number 2770 है मार्कर वाला जिंगल हमने पूरे बाड़ी दो 2/7/7 सुनो 2025 item 31 है ना This is an application for interim bail on the ground that the father of the petitioner expired 10/2025 due to prolonged illness, and the presence of the petitioner is necessary to perform the obsequious ceremonies. So, this matter was listed yesterday.
Day before yesterday.
This matter was listed on 13/10/2025. And he asked the Land Council for the state to obtain instruction. Accordingly, the Land Council for the state has given instruction received from IIC Seragod Police Station dated 14/10/2025, which indicates that the arguments taken in the interim application relating to the death of the father of the petition is correct. Stop. The written instruction is taken on record. Considering the submission made by the Land Council for the respective parties, the arguments taken in the interim application, the report furnished by the Land Council for the state, inclined to release the petitioner on interim bail for a period of 15 days from the date of release. While on interim bail, the petitioner shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Out of this matter will be commencing from 10th of November 2025. The Land Council for the appellant shall produce the surrender certificate of the appellant.
Copy in course of the day.
Copy in course of the day, 15 days.
Item 11. My lord, I have filed 2 IA. An appeal for stay relation of fine and appeal for bail.
Bail aguru reject it lagi. Janna di. କେତେ ଆଉ ସୁବିଧା ହେଲେ ଯୋଉ ଜାଣିବେ ତା ଅର୍ଡର ସେଗୁଡା ସବୁ ବାହାରି ଆସିବ।
My lord, the appellant is in jail.
କଣ କେତେ ବର୍ଷ ହେଲାଣି?
7 days.
7 years.
7.
We have to take him.
କେବେ କଷ୍ଟଡି ଗଲେ? ଏ ତାଙ୍କର ଫାଇନାଲ କଣ? ନା କଣ? ରଜ
Rajya Mohan.
15/1/2008 ହେଇଛି।
ଆଜ୍ଞା।
7 years କଣ?
So 17 years.
କଣ?
So 17 years.
ବେଲ ନଥିଲେ ଆପଣ ଇଏ ବେଳେ ଟ୍ରାଏଲ କୋର୍ଟରେ ବେଲ ନଥିଲେ? In custody, accused in produced in custody, produced in custody. ନା ଆଉ ଏ ହାଇକୋର୍ଟର ଅର୍ଡର ସିଟଟା ଦେଖିଲେ? P02 case.
Again.
Murder କାହାକୁ?
That is wife. Parsamani Patra.
Recovery kerosene.
Premature release by premature release by recommendation ହେଇଛି।
ସେଟା they have to take action, sir.
ଦେଖନ୍ତୁ IA number 326 of 2025. This is an application for bail. It appears that the petitioner was taken into judicial custody on 15/1/2008 and he was neither released on bail during the time nor during pendency of this. He has remained in custody for more than 17 years. Land Council submits that even though paperwork has been prepared, since there is no chance of early hearing, the bail application may be favorably considered. Land Council for the state offers the prayer for bail. Considering the submission, period of detention of the petitioner in judicial custody for more than 7 years and absent of any chance of early hearing, we are inclined to release the petition state relation of fine. urgent copy ଦେଇଦେବେ ଆଉ order be communicated also to the line district judge by the registered judiciary the relation of time.
Kindly release on bail with any term and condition.
Order টা বুঝি পারলেনি কি? Yes.
Warrant issue is like that, so there that will let go that. Whether he is arrested, that instruction is not there as per report 69. Social jail pata chaudhar has been acted. It 2011-2023 से there has been order.
तो 2 मास में दिया इतना तापर गला फिर तापर अनवेलेबल वारंट ऑफ अरेस्ट होईची आपण एग्जीक्यूट how you will come to know. You see, warrant, she found Koila, the convict warrant has been sent to the Court of Additional Session Judge Khurda.
Therefore, there is no information in that report.
So, IIC को कोई था तो सिजाई था ता कोर्ट को बुझ था कौन हला वारंट है
You will obtain that from my.
अल्टीमेटली सी IIC पाकू ही आसीओ एडीजे को पाखरु गले एडीजे तो फॉरवर्ड कर दी थी IIC पाकू
IIC should go to court and get the information.
69
यदि निजे एग्जीक्यूट करि पारिनी IIC कोर्ट रु वारंट है पर्यंत हे पर्यंत अब आपण ए जो सीनियर सुपरिटेंडेंट करो एटा पठै देले कोन हो
Being notice चेतियो दुनिया तो
by next week will be from IIC.
jail superintendent what will do?
No,
Get a press report.
Look, the Land Council for this has produced the report of the Senior Superintendent Circle Jail Kattakat Chodwa dated 16/9/2025, which shows that the appellant was released on bail. But as per the order of the court, but since subsequently non-bailable warrant of arrest was issued by the additional session judge for the arrest of the appellant, and no more information is available with the jail authority. The report is taken on record. देखा जाओ मैडम पेपर वो कर the learning council for the state seeks some more time to obtain instruction to the IAC for the police station as to whether the non-bailable warrant of arrest, about the status of the non-bailable warrant of arrest, which issued for arresting the appellant as per the order dated 20/11/2023. Hello? Stop. A similar report may be called for, and for such purpose the file be placed before the learning register judiciary. Hello? A free copy of the order is handed over to the learning council for the state. ଆପଣ ଆଣନ୍ତୁ ଆମେ କୋର୍ଟ ଜରିଆରେ ବି ମଗେଇଦେବୁ। ଏଇଟା ହିଁ ଚିଠିଟା। ये पर डेट देगी 27 तारीख को। Yes, next.
Item 13.
Sandeep Mahanti.
Your petitioner has been convicted under section 302, sentenced to life imprisonment with fine for committing allegations committed murder. He was a laborer.
The instruction.
All for the
Instruction that custody certificate antecedent webs for the notice.
Other thing.
1/9/2025 ର order ହଉଛି
months,
15 years.
more than 50
He
around
was
50
taken into custody on 19/12/2009. And you took time to obtain the criminal antecedent and also to produce custody certificate.
1/9/2025.
The order was passed on 1/9/2025. Then it was listed on 17/9/2025. Then on 53/9/2025. And again, we are on 15/10/25. You have not received it.
Wait for next week or because we are
you IA number so and so. This is an application for bail. When the matter was taken out on 1/9/2025, the submission was made that by the Land Council for the 2025, and we directed that the instructions shall be obtained in the meantime. 9/2025, we directed the matter to be listed in the week commencing from 22/9/2025. The matter was then listed on 23/9/2025, and again the Land Council for the state sought time to obtain instruction, and accordingly the matter was directed to be listed today. Land Council for the state submits that he is yet to receive as per the order dated 1/9/2025. And he seeks some more time, not inclined to grant more time to the Land Council for the state, as the case has been adjourned for such purpose on 3 occasions. Moreover, we have verified the records and found that necessary in accordance with law, for example, account the period of detention of the in accordance with law, for example, account the period of detention of the petitioner for more than 13 years, and since the appeal was petitioner for more than 13 years, And since the appeal was not ready for, accordingly, ordered, in the operative portion where we have used the words as interim bail, the same shall be read as bail. Hello? The rest part of the order remains unaltered, certified folks. Yes. Okay.
Item 15.
Item 15, my lord. The appellant in September 2014.
Just a minute. Short span of time, we can grant you bail when we have rejected it on 9/7/2014.
It's about
Any other
1 year
ground?
already. After 1 year, my lord, I filed for reconsideration of my 389 application afresh, my lord, because I appended my I obtained 2 RTI applications, my lord, where it clearly states that, my lord, the present appellant tried to save her wife at the time of burning, your lordship.
Put up this matter after January 2016. Yes.
Item 16.
May.
2020. Yes, item 16.
May I please, Lord? I have filed a IF for bail. Appellant convicted under section 302 and 302 and sentenced to undergo array for life and a fine of rupees 10,000. Custody since 21/2016. 9 years, 9 months.
21/6.
21/2016.
On material, on
Evidence copy, let's say evidence copy is not with you, only judgment.
bill ta file kala jale. Abun ki mana go lagi. The evidence copy na open. You have been engaged by the legal aid.
ଯାଇଥିଲି ଯେ ସେ କହିଲେ କି କୋର୍ଟ କୁ ପଠେଇ
Take soft copy in that.
The Ms. Anima Kumari Dei, Learning Council, submits that in order to place the bail matter, he may be supplied the soft copies of the evidence of the witnesses examining the trial court in our pen drive. Let the registry supply of the witnesses to the Learning Council in our pen drive. As in Asia,
We may also allow to.
the Learning Council for the state also makes similar clear that he also be permitted to take so on so. As in Asia,
Okay.
a matter be placed for them to list this matter in the week commencing from 27th October 2023. Yes.
Item 17.
My lord, therefore then, I number 268/2025, offense committed under section 3 of IPC. My lord, date of occurrence 9/6/2022. My lord, occurrence of offense that day.
Custody को अपन 11/6/2022 रे जाते हैं.
3 years, 3 months, 22.
Custody period सेते में बाकी कौन हो मेरिट रे कौन हो जजमेंट बात हो.
My lord. And the case of the resolution as and from the FIR in and college on date.
Eyewitness section थी.
2022.
Eyewitness section थी.
789.
789.
789.
Three eyewitness.
789.
कोउथरे मारले
Lathi.
लाठी रे मारले कई जाता को मारचंती.
Sudden provocation.
हां सडन प्रोवोकेशन एटा इंजुरी है तादे देखते हैं एक्सटर्नल इंजुरी 6 रे lacerated wound mid frontal area of this one so lacerated wound मुंडो को जोड़ा है आगे मराला तापरे फोर आर्म तापरे एल्बो को तापर mandible रे abrasion आसी multiple minute abrasions ones for left hand
This is due to head injury.
आपसे on the surface of the one to some to
Intention.
fracture पूरा cause of death is due to head injury. ये हमारी अभी का कौन सा वधिया फिगर कंप्लीट है January 2026. Next.
Item 18.
Yes, sir.
I know the hospital's directed to obtain the instruction relating to conduct
Custody certificate.
Yes.
Instruction regarding criminal treatment, conduct of.
and period of custodial pay.
One five 2007.
My lord. One, two, the police says, the IO says the arrested.
One.
1/5/2007.
या तो कोई आपने गोटा कौन आउट न कोई
नहीं पुलिस को 1-2 बोली कोई
कंफ्यूज करिया पे
नहीं 1-2 बोली लिख दीजिए
4 वर्ष 6 मास आओ conduct is satisfactory. लोगों को दिया था हम विलेज रामचंद्रपुर चल कोई क्यों जगह आओ रिपोर्ट में Are the land council for the petition land council for the state land council for the state has established the custody certificate of the petitioner which shows that he has remained in custody for more than 16 years, 6 months, and his conduct is satisfactory, and there is no criminal antecedent against the petitioner. The reports are taken on record. Considering the period of detention and judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed. Next.
Item 19.
Item 18, it is a mistake in our office, my lord. Notice letter has not been issued to obtain the conduct of the applicant on interim bail. It will pray for some time.
IAC घटना to and
Yes, my lord. Letter time of office which means
issue ही नहीं. But 12/11/2024
Yes.
के order लगी.
12/11/2024.
हाँ. अच्छा, let's come.
For sale.
IA number 2366 of 25. This is an application for bail. Surrender कर देगी जल्दी.
This is instructions on
certificate.
Surrender certificate अंदर नहीं.
I'm permitted to
bail ले जाइए ना अपन custody option ही नहीं क्या नहीं हमने.
confirm my lord. The meantime, you can confirm. Confirm my report by confirm lordships.
Criminal appeal था.
आपण जानने की surrender है लगनी.
This was instruction got copies with me.
You have not even mentioned in the petition that as per the orders such and such, he was granted interim bail and after availing the interim bail period, he has surrendered. Where have you mentioned? Neither you are filing the surrender certificate nor mentioning anything. As if माने जे first time जे bail move करनी सही type रा अपन.
I copy also not sub.
Is there any?
I will collect your lordships. Up to certified copy also.
हाँ. अच्छा, देखो. Give a copy also the interim application. This is an interim application for bail. Let a copy of the interim application be handed over to the land council for the state in course of the day. Stops. It appears that the petitioner was granted interim bail for a period of 3 months. By order dated 12/11 in IN number 281 of 2024. Though the land council for the petitioner submits that after availing the interim bail period, the petitioner has surrendered before the land and trial court, but there is no such averment taken in the interim application, nor the surrender certificate has been filed with the interim application. Land council seeks some time to produce the surrender certificate, put up this matter on 27th of October 2025.
Out of the throne.
Acha. Since Mr. Chittaranjan Sahoo has already entered appearance, sole petitioner.
Yes, my lord.
For the sole petitioner, the name of Mr. Arijit Mishra. ये आप तो कटी जीव तो Mr. J.R. Patnaik, S.K. Panda, S.P. Mishra, P.C. Mishra, S.K. Jena shall not be recalled this henceforth. ठीक है.
Item 20.
Mr. Poriya.
As per order, order 8/9/20.
Be little louder, yes.
8/9/25.
8/9/25.
I would report my copy.
Yes, I am sorry.
Abhimanyu I inquired from the matter so from the assertion of good behavior. Locality interim bail for Achakisi. One corner.
Intent.
ସେତେବେଳେ କେତେ ବର୍ଷ ରହିଥିଲେ ବୋଲି ବେଲ୍ ଦିଆଯାଇଥିଲା?
Bail ପାଇଥିଲା
10 years 7 months. Paper book not prepared also.
It's 1/8/2014. 1/8/2014. 1/8/2014.
ଗଣ୍ଡଗୋଳ ତ କରୁନି. The land council for the state has IN number 1152 of 2025. There is an application for bail. The land council for the state has produced the written instruction received from IIC R. Udayagiri Police Station, dated 15/10/2025, which show that during the interim bail period, there is no adverse report against the petitioner. The report is taken on record. The petitioner was granted interim bail for a period of 3 months. Taking into account, I would like to 3 months later. By the order dated 2/12/2024. Take his period of detention for more than 10 years and 7 months. And that there was no chance of early hearing of the appeal. Stop. Since after availing the interim bail period, the petitioner has surrendered at the right time, and he has not misutilized his liberty, and no adverse report has come against him, and there is no likelihood of the appeal being taken up for hearing. Trying to release the petitioner on bail granted. Next.
Item 21.
number 5 put to 25 mail. Order dated mail 8/9/25. Appealing report was called for.
ଯାଇଥିଲେ ଆଗରୁ
Ma'am,
କାହା ପାଇଁ ଦେଇଛନ୍ତି ଏଇଟା
I am 3 and 4 mail.
3 and 4 3 and 4 ଯାଇଥିଲେ ଆଗରୁ
Yes.
period of 3 months କଣ ଆସିଲା ବୋଲି
No adverse.
Bhagavati Dora and Sadashiv Dora.
Yes.
ଭଗବତୀ ଦୋରା ସଦାଶିବ ଦୋରା ଗୁଡ୍ ବିହେଭିୟର କେତେ ବର୍ଷ ରହିଲେ ବୋଲି ଯାଇଥିଲେ
10 ବର୍ଷରୁ ଅଧିକ ବର୍ତ୍ତମାନ 11 ବର୍ଷ
Authority certificate.
ଅଛି
Yes. It was.
କାଇଁ ପଚାର ନାହିଁ ଆଗରୁ ଅଛି
file mail na.
Authority certificate of conduct of the.
No mail. This fresh mail. Month of May mail.
ଏଇଟା ହଉଛି 1/5/2025 ର ଏଇଟା କେତେ ଦେଖଉଛି ଆଚ୍ଛା ଏଇଟା ଦେଖଉଛି 10 ବର୍ଷ 4 ମାସ 26 ଦିନ ଏଇଟା କାହାର ଏସ୍ ସଦାଶିବ ଦୋରା ବାକି ଆଉ ଗୋଟେ ଏସ୍ ଭଗବତୀ ଏଇଟା ତାର କେତେ ଅଛି ପିରିୟଡ଼ 10 years 4 months ଆଉ
10 years 4 months.
ଆଚ୍ଛା ଦେଖନ୍ତୁ
Bhagavati Dora.
Heard the Land Council for the petition, Land Council for the.
Single murder count.
IA number 542 of 2025 is an application of appellant number 3 S Bhagavati Dora and appellant number 4 S Sadashiv Dora. The Land Council for the petitioner has produced the custody certificate of the petitioners, which shows that they are in custody for more than 10 years. The custody certificates are taken on record. The petitioners were directed to be released on bail for a period of 3 months. And since they have surrendered at right time, and they are in custody for more than 10 years. And the Land and Council for the state has produced a report from IAC Patapur Police Station dated 15/10/2025 to show that nothing adverse was reported against the petitioners during the period, and absence of any chance of public hearing of the appeal in the near future, we are inclined to bring the petitioners on bail. Let appellant number 3 so and so and appellant number 4 so and so be released on bail. Now the case operative partner on the one
Item 22.
Your Lordship, the matter kindly be posted to next week. Mr. Dhal is appearing in a special mention in old building committee.
Mr. Das?
Yes, my connecting of the
Next week?
Yes, my ads for this just
Mention is, what is your good name?
BM Biplab.
Mr. B, it has been performed like that. CRLA number 88/2019. Mr. B and Biplab, Land Council appearing for Mr. DP, 6 for an adjournment. Put up this matter along with CRLA number 419 of 2019. on 22nd of October 2025. है ना? अविता प्रतिबंधी 419/2019 में Mr. Devasnan Das, Land Council for the appellant or appellant?
Only
Appellant is present. Stop. Place this matter along with CRL number 88/2019 form IC/2025. Yes.
Item 23.
And on item 23, the petitioner initially filed a has mentioned that no criminal antecedent. Subsequently, after filing a criminal antecedent of the petitioner filed a comprehensive affidavit that was sent to the police mailor. That report, verification of regarding the genuineness of that, whether he released on the Asina.
Since there are some criminal antecedents against the petition and a comprehensive affidavit has been filed by the London Council for the appellant relating to the status of those cases, as copy of the same has been served on the London Council for the state, who has sent the same for verification, it is the Land Council for the state since some time put of this matter in convention from 27th October 2020.
If Madam, I have never stated I have no criminal and I have
Based on
stated.
IRA.
IRA have stated.
No, they will verify.
Yes, sir. He has stated initial stage, I have not filed any, filed that no antecedent, but I have mentioned. Because earlier verification was rejected.
ये जहाँ कौन तो अपन लोगों ने comprehensive fact भी
I have already
फाइल को देना verify करे हो जाएगी और
Yes.
yes, next.
Item 24.
Yes, Mr. Das.
My lordship. My lord, the matter. The judgment dated 29/10/2019, my lordship. The judgment dated 29/10/2019, my lordship. Conviction for life and under section 302 of IPC, my lordship. Then, my lordship, the IA is pending for bail, my lordship.
Custody since?
Custody since
7 years,
and
8
11
months.
months.
7 years?
11 months.
एटा काहे की छुट्टी पर रहितला हम बोले दबा को
My lord, eyewitness.
हम दबा को बोले ये
Not inclined to the
not inclined to सब रखी ले उड़ा तो आई से
eyewitness is there?
Yes, eyewitness there, but not directly seen the occurrence policy. While the accused person is left the house, then the eyewitness is seen. But surprisingly, my lordship, that one of the witness, the witness number 7, is the one of the is sleeping beside the deceased, but he had no knowledge regarding the incident.
At 27 leading to this.
Assaulted by on the head as it appears.
Yes, my lord.
Because the doctor who conducted postmortem examination, he noticed fracture of the temporal. I think it's a number of injuries were there.
No, single 5 to 6.
Who is eyewitness? PW?
One.
X-ray marle pra?
Yes, ma'am. Single blow.
And while the petitioner was in custody, he confessed the guilt and led to discovery of the
27 acts मिली जी जो आर कौन antecedent कौन
antecedent मगाएंगे
London Council for the এটা लिखी हुई IN number 2257 of 2025. There is an application for the London Council for the state 6 some time to obtain instruction regarding the criminal antecedent, if any, against the appellant foot of this matter at November 2nd, 10th of 11, 2025.
Item 25.
Mr. Mishra?
The appellant has been convicted under section 302 IPC, sentence to life. But here the prosecution was leveled against 3 accused persons. And they faced the trial being charged under section 302 by 34 IPC. Now 2 have been acquitted. Now the appellant has been convicted under section 302 only. And he is in custody, my lord, since 23/3/2015.
22/3.
23/3/2015. That your lordship will get it.
Custody period 8 years 1 month.
8 year.
Yes.
23. He apprehended all the accused persons and arrested them.
Custody ଅଛି custody 23/2/2015 ରୁ 21/2/2015 UTP. After conviction 25/2/2020 ରୁ 17/4/2025.
Your lordship will get it on page 3 of the judgment.
What is the report?
Page 3 of the judgment.
ଏଟା କେବେକାର ରିପୋର୍ଟଟା ମଗେଇଛନ୍ତି?
17/4/2025 ପର୍ଯ୍ୟନ୍ତ।
ହଁ ଏ ଯଦି ଆମେ ଯଦି ସେ ଯଦି ବେଲରେ ବାହାରିନି ଆପଣଙ୍କ ଇଏ ଅନୁଯାୟୀ ବି ବେଲରେ ବାହାରିନି 23/3/2015 ହେଲା ମାନେ ତ 10 ବର୍ଷ ଉପରେ ହେଇଯାଉଛି।
ଗଲତ ରିପୋର୍ଟ
23/3/2015 ରେ ଆପଣ ଦେଖଉଛନ୍ତି ତ?
ନାଇଁ ବେଲରେ ଥିଲା ନା
ବେଲରେ ଥିଲା
ପୁଣି ପାଇଁ କାରଣ 25/2/2020 ରୁ ଅଛି 23/2/15 ରୁ 21/2/18 UTP। ତାପରେ ଆଫ୍ଟର କନଭିକ୍ସନ 25/2/20 ରୁ 17/4/25।
ଓ ସେଇ ଯୋଉ ବେଲରେ ଯାଇଛନ୍ତି ଆଉ ଆମ କହୁଛନ୍ତି ଦେଖି କେମିତି କଣ କହୁନାହାନ୍ତି।
23/3/15
ନା ତାପରେ ଟ୍ରାଏଲ ଚାଲିଲା ବେଳେ ବେଲରେ ଯାଇଛନ୍ତି। ଡେଟ୍ କୁହନ୍ତୁ ଆରେ ଡେଟ୍ କୁହନ୍ତୁ ଏଠି ଅଛି ଆମ ପାଖରେ ଅଛି
23/2/15।
23/2/15 କୋଉଠି ହେଲା? He was apprehended on 23/3/15.
बेल ट्रायल कोर्ट बेल के पहला
এটা ହେଲା 21/2/2018 21/2/2018 ଦେଖିଲେ ଜଣାପଡ଼ିବ। 21/2/2018 hard the petition in presence of so and so be released on bail ରହିଲା ଆଉ କଣ ବେଲେ ଯାଇଛି ଠିକ। ତ ତାନୁ ମାଝି ହଉଛି
21/2/18 ରୁ 25/2/20।
ହଁ ଯେ ଜଜମେଣ୍ଟ ପର୍ଯ୍ୟନ୍ତ।
He was arrested on 23/3/15.
Then bail granted on 21/2/18.
During trial he was granted bail
21/2/18
21/2/2018 ତାପରେ ଜଜମେଣ୍ଟ ହେଇଗଲା ପୁଣି again
25/2/20 again arrested।
25/2/20 obviously date of judgment ହେଇଥିବ ଆଉ କଣ ଦେଖି ଜଜମେଣ୍ଟଟା ଡେଟ୍ ହଁ 25/2/20 ଜଜମେଣ୍ଟ
25/2/20
ତାହେଲେ ଆପଣଙ୍କର ଆସୁଛି
2 ବର୍ଷ 2 years
8 years 1 month 22 days up to April।
8 years ଆସୁଛି
ଆଉ 6 ମାସ ବଢିବ ହେଲେ 8 years 7
ହଁ ଏଇଟା ଯୋଉ ଆଚ୍ଛା କେବେକା ଏଠି
17/4/2025 ପର୍ଯ୍ୟନ୍ତ ହେଇଛନ୍ତି।
17/4/20
25/2/20 ରୁ
6 ମାସ ବଢିବ 6 ମାସ ବଢିଲେ 8 ବର୍ଷ 7 ମାସ ହଉଛି। ଆଉ କଣ ଏଭିଡେନ୍ସ ଅଛି?
Evidence is PW
7 and 8 eyewitness।
7, 8, 19. Now they say that these persons, they came to their house in a drunken condition and picked up quarrel with the deceased. The accused persons.
Knife.
8 p.m.
2 accused cut hold up for the deceased and you gave the blow.
I inflicted the knife blow.
The 2 accused have been acquitted.
And the knife doesn't contain also the chemical reagents.
PM report with the doctor.
16.
The knife also did not contain blood.
Recover at your instance.
You have also find
stabbing.
There is a stab injury.
Two
Dita
stabbing.
ତାକୁ ଦି ଜଣ ଯାକ ଧରି ପକେଇବେ ଇଏ ପଛଆଡୁ from the back side. And I also sustained injury.
You examined?
Oh, yes.
Doctor examined you?
Yes. So that your lordship will get it from the evidence of paragraph 4. On the same day, I have also examined Sisubal Majhi and found one old lacerated injury with stitches size of 2 centimeters, left lateral and anterior.
Simple injury.
Simple injury.
Tussle, definitely he will sustain injury. Tussle.
ये कौन अच्छी माने और जो criminal
that has not confirmed.
The convict is maintaining a peaceful and disciplined life. His convict Heard the land council for the petition, land council for the state. The land council for the state has produced the custody of the stores. That the petitioner is in judicial custody for 8 years, 7 months. He has also produced the report from the superintendent district department to show that the conduct of the petitioner inside the jail is satisfactory, committed any prison offense and maintaining a peaceful and disciplined life. The reports are taken on record. Mr. Mishra counsel submits that the prosecution case is mainly based on the evidence of 3 eyewitnesses, that is PW 7, 8, and 19.
And 19.
19.
1.
7, 8, and 1 and 19. So the evidence of the doctor back at the PW post-mortem examination. He submits that it appears that there was some conflict between the petitioner and the appellant, for which the assault took place. And since there are no chances of early hearing of the appeal in the near future, the bail application may be favorably considered. When counsel for the state opposed the prayer for bail and stated that eyewitnesses have specifically stated that the petitioner dealt the knife blow on the back of the deceased, and the evidence of the doctor corroborates the version of the eyewitnesses, and the doctor has stated that the cause of death of the deceased was due to hemorrhage and hypovolemic shock. Considering the submission made by the land counsel for the respective party, in view of the eyewitnesses account of 3 witnesses, so also the medical evidence, while not inclining to believe the petition, but taking into account his period of detention in judicial custody and the ratio laid down in the case of Letty versus Swans, petition is directed to be released on interim bail for a period of 3 months. Baki jo usual order for the state relation of fine. Yes.
Item 26.
It's of triple murder.
After non-appears, after January 2026. Yes, next.
Item 27.
This case last time we also called for the department by report that status of the daughter who was reading in the class school.
I think the daughter of the petitioner is now studying in English medium school at Jaipur, Koraput. Time of
At the time of occurrence, he was in 1.5 lordships. And till that he has not seen the daughter and not allowed to the family member also my lord. And he is a custody my lord. So
what is the allegation against the petitioner?
Allegation is my lord is a custody committed to wife my lord.
Wife.
Yes. And it is the point out of my lord. Out of a year, para judgment to fit my lord. The investigation officer has reported that the immediate cause of trouble is suspicion of the accused Sujit Sardar on the character of decision out of anger. He picked up
Period of custody.
7 years, 7 months.
Huh?
7 years, 7 months.
27/3/2018 ଅଛି।
28
ତାହେଲେ ଆପଣ 27/3/2018
Lordship kept it after vacation.
ବେଲ୍ ଯାଇନଥିଲେ ଇଏରେ
No, my lord.
ଟ୍ରାଏଲ କୋର୍ଟରେ
No.
ଦେଖିବା accused production ତାହେଲେ ଆପଣଙ୍କର ହଉଛି 7 years 6 months ହଉଛି ଆଉ ଏଭିଡେନ୍ସ କ'ଣ ଅଛି?
No witness, Lord. I witness not.
ଆଇ ୱିଟନେସ୍ କୋଉଠି ଆସିବ ଘର ଭିତରେ କଜ୍ ଅଫ୍ ଡେଥ୍ କ'ଣ?
Cause of death, my lord, got throat injury leading to.
କେତେ ବର୍ଷ ବାହାଘର ପରେ?
My lord, ବାହାଘର ହେଲା 2012.
13/3/2012
Marriage.
ଘଟଣା ହେଇଛି 26/3/2018
26/3/2018
6 ବର୍ଷ ପରେ।
Child must be about 5 years.
1.5, now is 9 years. At the time of occurrence, it was 1.5 years.
You have not seen your daughter. That is your ground.
Even if not allowed to see family members also.
PW2 evidence is you have inflicted number of blows. It's not a one blow. Incised cut injury on the face, again incised cut injury, another on the neck, hard incised cut injury on the neck muscle, out incised man kitna incised ଦେଇଛନ୍ତି? No. Pasta, shorter. 6 injuries have been caused. All are on the vital part. Neck, pec, so here are focused on the January. Next.
Very brutal killing.
Next.
Item 28.
Yes, Mr. Mishra. Realization of kind of allowed person.
The custody is about 8 years. I have submitted my the address of the.
Custody since 2008.
Yes, madam. Date of arrest is 16th October 17. I have to custody to 17 October 17. Exactly 8 years. Convicted on 302, specially basing upon the statement of his son, PW5.
Child witness.
Yes, my lord.
ବର୍ତ୍ତମାନ କ'ଣ କରୁଛି ସେ ଛୁଆ?
Cross-exam stated that at the time of the occurrence, my mother.
My father has
Item 29.
Nine. ठीक है, be louder. सुगुनी आप के पार्टी करी कौन के जोरे कौन सुगुनी कौन
Actually, two appellants, my lord, one up, two appellants, my lord. The other appellant has already reached, my lord. And this is, my lord, under 498K 302 by 406.
This bail application has been filed for appellant number 1.
Yes, my lord.
So
Appellant number 2 is, my lord, already released on bail by this honorable court, my lord.
by which order?
On same footing, my lord. He is uncle of this appellant, my lord.
You are the husband.
Yes, my lord.
Uncle could also start saying na husband upon
Appellant number 2 has already been released by bail by this honorable court, my lord.
Custodian shares court.
Yeah.
Even I would appeal file na he appeal hai.
No. Rajaram Bera.
Rajaram Bera, when he was granted bail, acha, 19/12/2022.
For the first time, my
It
lord.
was considered that appellant number 2 was on bail during trial and he has not misutilized the liberty. The direct involvement is of appellant number 1. ତେଣୁ ଆପଣ ମାନେ 2 ନମ୍ବରକୁ ବେଲ୍ ଦିଆଗଲା। ତ ଯେହେତୁ Villa appellant number 2 is no main allegation is against him, which is against you. That was the reason. No, how same footing upon केमती कहउछंदी वर्तमान
7 years 4 months.
What is the cause of death?
My lord.
Cause of death कौन? पढ़ी ना दी?
My lord.
पढ़ी ना नहीं। ଆଉ କିଲେ ନବା ନା କଣ କହୁଛନ୍ତି କୁହନ୍ତୁ?
Death by doctor's evidence, my lord, asphyxia, my lord.
डॉक्टर कितने नंबर साखी?
My lord, 22, my lord.
PW 22. अच्छा देखिए PW 22.
My lord,
23 my lord. 23.
all the independent witnesses, my lord, they are telling, my lord.
Wait.
And the deceased mother also, my lord, PW9, she has also told, my lord, that she was
cerebral anorexia, cause of death, it's a homicidal.
Also good conjugal life.
Ligature mark found around neck. Disease starting below the thyroid cartilage, all around the neck. Rossire chipaigin moraigis. It was due to compression of the neck. That is how it has been opined to be homicidal in nature. So, ବାହାଘର କେତେ ବର୍ଷ ପରେ ଘଟଣା ହେଇଛି? ବାହାଘର କେତେ ବର୍ଷ ପରେ ଘଟଣା ହେଇଛି?
After 8 years, 2005, my lord, marriage, 2013, this occurrence happened.
कौन अच्छी मिस्टर?
After 13 years, my lord, 2018, my lord, occurrence happened. Marriage 2005.
22, my lord. Mother of the deceased. कौन सी पूछ?
I know the informant Chitrasen Bera, who is my son. I know the accused one Rupati Bera standing in the dock. I know the deceased Dipakanti Bera, she is my daughter. We had given our daughter Dipakanti Bera in marriage to the accused Rupati Bera as per the caste and customs. During the time of marriage, we had presented some articles as per demand of the accused persons. But the accused person demanded a motorcycle from my daughter, for which
my daughter called on us over phone and intimated to fetch them a motorcycle. The active persons were also torturing my daughter over demand of motorcycle. We would not fetch the active persons a motorcycle, but paid them some amount for the same. On the night of occurrence, my daughter made a phone call with me to come to her place. For torturing. As it was night, we did not proceed to her in-laws house. But on the next day, we got information that the accused person has committed murder of my daughter. We proceeded to the village of the accused person and found my daughter laying dead on the floor of the house of the accused. There were injuries on the neck of the deceased and on her knee. I, along with my husband and some of our relations, had been to the house of the accused person, and after getting information about the occurrence, I was examined by police investigation.
We come to cross-examination, fourth sentence.
Happy conjugal life.
My daughter and her
10 to 12
husband
years.
lived happy conjugal life for about 10 to 12 years. During that period, they were also pulling well with us. We had 10 relationship with the accused, my son-in-law after the death of my daughter. I had to the village of the accused after death of my daughter. I found my daughter in the house of her in-laws. I have not seen her hanging from the ceiling of the room. It is a fact that we have not made any complaint to the police.
Who else are staying in the house? Who else are staying in the house of this man? That means petitioner or deceased. ତାଙ୍କ ଛଡା ପିଲାପିଲି କେଇଟି?
Anybody else was there in the house?
I don't know, madam. Pillapilli Visaya.
Evidence
In the
is your
judgment also there is no mention. Well, after 13 years of marriage, this occurrence happened, my lord. The mother, my lord, of the deceased, she is staying in, my lord. Had a good conjugal life, and they were happily conjugal life for about 10 to 12 years.
That we read out.
Up till the year it has happened, my lord.
But the homicidal death, we are putting this question for a particular purpose, that whether there are other family members or not.
No, my lord, no other family members.
So if you are there only, then how do you discharge your burden on 106 of the Evidence Act? If you are alone with your wife and your wife died homicidal death, there was ligature mark around the neck and the neck was compressed. You are to explain how the deceased died. But your reply in your 313 statement is false, false, false. Nothing is stated. Are the learned counsel for the petition of the counsel for the state? The learned counsel for petitioner submits that the petitioner along with Rajaram Behra faced trial in the trial for offenses cancelled under section 490 and 302.
And facts.
Rajaram 406 01 by 34 of the Indian Penal Code and section 4 of Dowry Prohibition Act. And the learned trial court found both of them guilty under section 498 302 201 by 34 IPC and section 4 of Dowry Prohibition Act. The co-accused Rajaram Behra has been granted bail by the court by order dated 19/12/2022. It is argued that the petitioner stands in
similar footing. And he is in judicial custody for more than 7 years. And the occurrence in question took place about years. 10 to 12 years. Now, exact
13
date.
years.
About 12 years after the marriage. And the evidence of the mother of the deceased, who has been examined as PW22, shows that the deceased and the petitioner were leading a happy conjugal life for about 10 to 12 years. The council submits that in view of the available material on record, the bail application may be favorably considered. Land Counsel for the state, on the other hand, opposes the prayer for bail and submits that the petitioner is not similarly situated like the co-accused Rajaram Behera. And the doctor, bracketed PW23, who conducted post-examination, has opined the cause of death was on account of neck compression, which is homicidal in nature. Though there is no direct evidence in the case, but since the petitioner was residing with the deceased and he has not discharged burden by stating as to how the deceased made a homicidal death, the bail should not be granted to the petitioner. The Land Counsel for the state, however, has produced the custody certificate from the Superintendent Subjail Fantamanji, which indicates that the petitioner has remained in custody for 7 years, 4 months. So, he has also produced the report from the OIC Turkela Police Station dated 27/2025, which shows that there is no criminal antecedent against the petitioner. Both the reports are taken on record. Considering the submission made by the Land Counsel for the respective parties, the nature of evidence adduced during trial, and the post-mortem report finding, while not inclining to release the petitioner on bail on merit, but taking into account its period of detention in judicial custody and absence of any chance of further, we are inclined to grant interim bail for a period of 3 months. Accordingly, pass the order. Yes. Next.
Item 30.
When was in item 30, Mr. Devashish Panda is to appear. We have filed his memo of appearance at the registry. I pray the matter may be taken up next week.
File कर दी जल्दी.
Madam, at the registry.
अच्छा, it is stated at the bar that Mr. Devashish Panda, Land Counsel, has filed the appearance memo in this case, and the same may be placed on record. And the name of the Land Counsel be reflected in the cause list. Put of this matter in the week commencing from 27 October 2025, indicating the name of Mr. Devashish Panda in the cause list and his appearance memo should be placed on record. The rest of the matter will be
leftover matters may have taken to the top of it.
MC computer तो तक ये कोई
7-8
पूर्ण मैटर पूरा माने
नोटिंग ऐसे नोटिंग रिकॉर्ड
अच्छा देखिए
आइटम नंबर 26 कॉल मला
महाती कितना नंबर अपन करो
32
32 टन हवा तो से सोमवार दिन सॉरी ये दिन
शुक्रवार है
शुक्रवार
Metal